Sir, quota number 7 is voice clear?
Yes, sir.
Sir, ನಿಮ್ಮ ವಾಯ್ಸ್ ಸ್ವಲ್ಪ ರೈಸ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್ ವಾಲ್ಯೂಮ್.
ನಮ್ಮ ವಾಯ್ಸ್ ರೈಸ್ ಮಾಡಿ. ಇಲ್ಲ, ನನ್ನ ವಾಯ್ಸೇ ಇಲ್ಲ ಇವತ್ತು, ಹುಷಾರಿಲ್ಲ.
So first there will be submissions through VC with regard to any
Okay.
adjournments. After VC, any memo submission. After memo submission, any adjournment from the.
Thank you.
Any mentioning through video?
Mallots, serial number 17 Mallots. It's a compliance Mallots, office objection. May I seek 1 week time to furnish the proper address?
2019 matter, will see when the
Yes,
matter.
Mallots, yes, Mallots. Data is not found. What is the Shara
We
has
will see when the matter reaches. It is 2019 matter. Yes. Any other submission through video?
My lord, in serial number 62, my lord. I am for the petitioner.
Yes.
Since from 2 days, my lord, I am suffering from fever and as well as the throat infection. I could not able to contact the other side advocate also.
Work for the petitioner.
Yes, my lord, I am for the petitioner.
Learned counsel for the petitioner who is appearing to video conference stating that he is not keeping well. Request for a short accommodation. A week's time as paid is granted. Yes.
And interim order may kindly be extended, my lord.
That you have to see when the matter reaches.
Much of
Yes, next. Is any mentioning here? Any memos?
Your Lordship, one matter, the company has challenged the liability. They have filed execution petition bearing number 1286 of 23, which is posted on 2710. They have challenged the liability, Your Lordship, in this case.
Tomorrow, please.
Serial number 7.
Any memos first? No memos. ಬನ್ನಿ ಎರಡು ಮೈಕ್ ಇದೆ ಯೂಸ್ ಮಾಡಿ.
ನೋಟಿಸ್ ಸರ್ವ್ ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ರು. ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆ ಕೈಂಡ್ಲಿ ನಾಳೆ ಬಂದ್ರೆ.
Tomorrow. Yes. Mentioning.
Serial number 73 ಮೇಲೆ.
73. Yes.
Kirimalaya's mother is hospitalized. She went to native Red Council.
The press counsel for the appellant citing that there is a medical emergency in the family of the learned counsel for the appellant pays for a short accommodation. A week's time as paid is granted. However, in the meantime, the appellant to comply. The office objections if any in the matter regarding the correction of the date of the judgment. Yes, one.
Please.
Serial number 63.
63, yes.
63, I have the confirmation.
Yes.
Kindly have it next week.
Why?
Today it's not well matters. Senior not well.
ನಮ್ಮ ಡಿಸ್ಪೆನ್ಸರಲ್ಲಿ ಡಾಕ್ಟರ್ ಕೆಲಸ ಇಲ್ಲದೆ ಕೂತಿರ್ತಾರೆ. ಇಲ್ಲಿ ನೋಡಿದ್ರೆ 100 ಸಂಖ್ಯೆಯಲ್ಲಿ ವಕೀಲರು ನಾಟ್ ವೆಲ್ ಎವ್ರಿ ಡೇ. ಏನಿದು ಸ್ವಲ್ಪ ಹೊಸ ಸುಳ್ಳುಗಳು ನೋಡ್ಬೇಕ್ರಿ. ಹಳೇದೇ 42 ವರ್ಷದಿಂದ ಅದೇ ಕೇಳಿ 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 ಬೇಜಾರಾಗ್ತದೆ. ಮೊಬೈಲ್ ಚೇಂಜ್ ಮಾಡ್ತಿರಂತೆ ಎಕ್ಸ್ಕ್ಯೂಸ್ಗಳು ಚೇಂಜ್ ಮಾಡ್ಲಿಕ್ಕಾಗಲ್ವೇ? Request of the learned junior counsel for the petitioner who submits that his senior is not keeping well. As a final last opportunity, week's time as paid is granted. Yes, next. No, entry ಮಾಡಿದ್ರೆ ಮ್ಯಾಟರ್ ರೀಚ್ ಆದಾಗ ಹೇಳ್ಬೇಕು. ಮೆಮೊ ಕೇಳಿದಾಗ ಮೆನ್ಷನ್ ಮಾಡಿದಾಗ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಕನ್ಸಿಡರ್ ಮಾಡಲ್ಲ. ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು. ಮೆನ್ಷನ್ ಮಾಡುವಾಗ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ನೋಡಲ್ಲ. ಅದಕ್ಕೆ ಆರ್ಡರ್ ಶೀಟ್ ತೆಗೆಸಿ ನೋಡ್ಬೇಕು ಇದೆಯೋ ಇಲ್ವೋ ಏನಂತ ಇದೆ. ಮ್ಯಾಟರ್ ರೀಚ್ ಆದಾಗ ಹೇಳಿ. ಎಸ್ ನೆಕ್ಸ್ಟ್.
Serial number 65, my lord. I appear for the petitioner.
57.
65, my lord.
Yes. Yes.
I appear for the petitioner.
Yes.
Senior is unwell, my lord. A short accommodation.
ನಾಳೆ ಒಬ್ರು ಡಾಕ್ಟರ್ ಬರ್ಲಿಕ್ಕೆ ಹೇಳ್ರಿ. ಇಲ್ಲಿ ಡಾಕ್ಟರ್ ಯಾರ್ಯಾರೆಲ್ಲ ನಾಟ್ ವೆಲ್ ಅಂತಾರೆ ಅವ್ರು ಫೋನ್ ಮಾಡಿ ಕರೆಸ್ಕೊಳ್ಳಿ ಡಾಕ್ಟರ್. ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ದ learned junior counsel for the appellant who submits that the senior is not well, the final last opportunity, a week's time as paid is granted. Yes,
April 9.
Serial number 51, my lordship.
yes,
They have to file some documents, my lordship. It may be given 1 week adjournment.
whom you appear for?
I am for petitioner, my lordship.
At the request of the learned counsel. And this time as paid is granted as finally. Yes,
Serial number 66, Your Honor.
yes,
Senior father ಮೈಗೋಚರಿಲ್ಲ, so ಅವರು ಊರಲ್ಲಿ ಇದ್ದಾರೆ, kindly 1 week of congestion is granted.
at the request of the learned counsel for the petition. Who submits that is not keeping well, senior is not keeping well, finally a week's time as paid is granted. Yes, call the case.
Serial number 55. Serial number 56.
Whom you appear for?
Appellate.
ಯಾವಾಗ ಪುಸ್ತಕ ಇರ್ತೀವಿ ನಿಮ್ ಸೀನಿಯರ್ಗೆ ಕೇಸ್ ಮಾಡ್ಲಿಕ್ಕೆ? ರಜೆ ಇಲ್ಲ ಆದ್ರೂ ಇನ್ನೂ ಇಲ್ಲ, ಇನ್ನು ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್ ಅಂತ ಹೇಳಿದ್ರೆ ಪಾಪ ಅವರು ಕ್ಲೈಂಟ್ಗಳ ಬಗ್ಗೆ ನಾನು ಸ್ವಲ್ಪ ಮರುಕ ಪಡ್ಬೇಕಲ್ವೇ?
Relation ಅದಕ್ಕೆ
ನಮ್ಮ ಏನ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ, ನಮ್ಮಲ್ಲಿ ಸತ್ತೋಗೋರು
witness
ನಾಟ್ ವೆಲ್ ಅನ್ನೋರು, ಪೂರ್ ಪರ್ಸನ್ ಅನ್ನೋರು ಕಂಡಾಪಟ್ಟೆ. ಸೆನ್ಸಸ್ ನಮ್ಮಲ್ಲಿ ತಗೊಂಡ್ಬಿಟ್ರೆ ಭಾರತದ ಚಿತ್ರಣವೇ ಬದಲು. At the request of the learned counsel for the appellant. ಯಾವ ಸಂಕೋಚ ಇಲ್ಲದೆ, ನಿರ್ಬಿಡೆ ಇಲ್ಲದೆ ಎಲ್ಲಾ ಸುಳ್ಳುಗಳನ್ನ, ಹಸಿ ಸುಳ್ಳುಗಳನ್ನ ಸತ್ಯ ತಲೆ ಮೇಲೆ ಹೊಡೆದಾಗ ಹೇಳಿದ ಅಡ್ಜರ್ಮೆಂಟ್ಗೆ ತಾವೇ ನೋಡಿ. ಈ ಕಮ್ಯುನಿಟಿ ಎಷ್ಟು ವರ್ಷ ಇದೆ, ಸಿಂಪಲ್ ಮ್ಯಾಟರ್ ಅದು.
ಈಗ ಬೆಳಿಗ್ಗೆ ನಮ್ಗೆ ವಿಚಾರ ಆಗಿದೆ.
The request of the learned counsel for the appellant as a final last opportunity. Which time as paid is granted. Yes, call the case.
Malcolm officer, first time, number 1, Venkatesh KM.
Counsel for the appellant may present physically in or through video conference. The result of the order sheet will go to show that in spite of granting sufficient opportunities of not less than 4 times, the appellant has not complied of this exception. As such, though the appeal could have been dismissed for non-compliance as well as for non-prosecution, however, considering the nature of the appeal, by denying the interest on the enhanced amount already declining in this matter, till the complaints of office subsection from the date of filing of this appeal. As a final last opportunity, a week's time is granted to comply of this objection.
For the appellate, my lord. I am appealing for the appellant, my lord. Pray for 2 weeks time, my lord, because I complied the office objection. One object is that wakalat of the appellant number 2 is not made out in the wakalat, my lord. That's why I have to bring the wakalat from them and to file it, my lord. That is the 2 weeks time, my lord. I will comply the
200 rupees per day. ಎಷ್ಟು ದಿವಸ ಬೇಕು ಹೇಳಿ? 2 weeks ವರೆಗೂ ಕೊಡಬಲ್ಲೆ. ಎರಡು ಆಪ್ಷನ್, ಒಂದು ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ, ಇನ್ವೆನ್ಸ್ಡ್ ಅಮೌಂಟ್, 1 week time.
1 week time.
2 weeks time at the cost of rupees 200 per day.
1 week time with 1 week time without interest.
12 ಸೆಕೆಂಡ್ ಒಳಗೆ ಮಾಡಬಹುದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಾಂಪ್ಲೈನ್ಸ್. ಯಾರ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಬೇಡ, ಏನು ಬೇಡ, ವಕೀಲರು ಮನಸ್ಸು ಮಾಡ್ಬೇಕಷ್ಟೇ.
ಅಪಲೇಟ್ ನಂಬರ್ 2 ವಕಾಲತ್ತಲ್ಲಿ ಸೈನ್ ಇಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ತರಿಸ್ಬೇಕು, ಅದಕ್ಕೋಸ್ಕರ ಅದಕ್ಕೆ ಇನ್ನೇನಿಲ್ಲ. ಬೈ ಓವರ್ ಸೆಟ್, ದಟ್ ಈಸ್ ಮೈ ಮಿಸ್ಟೇಕ್ ಮೈ ಲಾರ್ಡ್.
ಅದು ನಮ್ಮ ದುರಂತ. ಒಬ್ರು ವಕೀಲರು ವಕಾಲತ್ತಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ಇದೆಯಾ ಇಲ್ವೋ ಅನ್ನೋದನ್ನು ನೋಡದಂಗೆ ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ಫೈಲ್ ಮಾಡ್ತಾರೆ.
ಸಾರಿ ಮೈ ಲಾರ್ಡ್.
ನಮ್ಮಗಳ ಶಕ್ತಿ, ಬುದ್ಧಿಶಕ್ತಿ, ಮೇಧಾಶಕ್ತಿ, ಪ್ರಾಜ್ಞತೆ, ಯುನೈಟೆಡ್ ಕಾಮ.
I agree, my lord. It is my mistake.
The counsel for the appellant appearing through video conference, who initially requested for 2 weeks accommodation after the court gave a clue of imposing cost for complaints of office objection. The cost for granting further time has reduced the requirement by a week. Hence, as a final last opportunity, a week's time as paid is granted, failing which the court will proceed to pass appropriate order including dismissal of the appeal for non-compliance. List the matter on 2/11. Yes.
Bill number 3, Patil's yes.
Counsel for the appellant neither present physically nor through video conference. No reasons are forthcoming for his non-appearance. The result of the order sheet would go to show that in this appeal of the year 2019, in spite of granting several and sufficient opportunities of not less than 4 times, the appellant has not complied of his objection. The office objections, which are 13 in numbers, are simple in nature, which could have been complied with by the appellant without taking much time. Despite the same, from the date of filing for more than 4 years, the appellant has not bestowed his interest to comply with his objection. In the said circumstance, irrespective of the nature of the petition, suffice it to say that the appellant has shown his non-inclination to proceed further in the matter for complying of his objection. Hence, appeal into the petition and command. Hence, the question stands dismissed for non-compliance of the office objection as well as for non-prosecution.
Bill number 4, Shastri Associate, T.G. Shastri.
ಮೆಮೊ ತಯಾರು ಮಾಡ್ಕೊಂಡು ಬರ್ಬೋದಿತ್ತಲ್ವೇ? ಕಾಸ್ ಲಿಸ್ಟ್ ಈಗ ಬೆಳಗ್ಗೆ ಬಂತೆ ತಮಗೆ 10 ಕಾಲಿಗೆ. 4 ದಿವಸ ಆಗಿದೆ ಅಲ್ವೇ ಬಂದು? ಕಳಿಸಿ ನಿಮ್ ಸೀನಿಯರ್ನ ಕಳಿಸಿ. ಮ್ಯಾಟರ್ ಇಸ್ ಪಾಸ್ಡ್ ಓವರ್ ಅಟ್ ದಿ ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ದಿ ಪಿಟಿಷನ್.
Non-compliance 5th time, cell number 5, D. Manjunath.
Enabling to file the memo for withdrawal.
Representing the appellant in this case, my lord. I seek a week's time, my lord, to complete the office objections. This is an owner's appeal, my lord.
Land counsel for the appellant appearing through video conference once again placed for a week's time. Perusal of the order sheet would go to show that the appeal is of the year 2019 and sufficient opportunities of not less than 5 times have already been granted. Under the said circumstance, though the appeal could have been dismissed for non-compliance of office objection, however, imposing the cost of rupees 500 payable by the appellant to the Legal Services Committee of this court within 2 days from today, and filing, etc., as a final last chance, a week's time as spread is granted in case cost not paid, complaints not done to 11. Yes.
Cell number 6, Vaidya Ravi Lakshmi Narayan.
Lord, I appear for the appellant. Lord. A week's time may kindly be granted. Lord. Sorry.
Yes, please.
Lord, I pray for a week's time, Lord, to comply with office objection. With regard to valuation, Lord, the office objections are raised.
ತಮಗೆ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ನೋಡ್ಲಿಕ್ಕೆ ಎಷ್ಟು ಸಮಯ ಬೇಕೆಂದ್ರೆ ಹಲವಾರು ತಿಂಗಳುಗಳು.
I'm extremely sorry, my lord.
Karnataka Court Fees and Suit Valuation Act ಸರಿ ಓದ್ಲಿಲ್ಲ.
I'm extremely sorry.
ಮತ್ತೆ ಏನ್ರಿ ಅದು? ವಕೀಲರು ನಿಮಗೆಲ್ಲ ಫಿಂಗರ್ ಟಿಪ್ಸ್ ನಲ್ಲಿ ಇರಬೇಕು. ಅಬ್ಬಬ್ಬ ಅಂತ ಹೇಳಿದ್ರೆ ಒಂದು 10 ನಿಮಿಷದ ಕೆಲಸ. ಆ 10 ನಿಮಿಷದ ಕೆಲಸಕ್ಕೆ ಈ ಪಾರ್ಟಿ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಗಳು.
ಗೊತ್ತಿಲ್ಲ.
ಕಕ್ಷಿದಾರ ಎಲ್ಲಿ ಹೋಗ್ಬೇಕು ಹೇಳಿ.
Somehow I lost track, my lord. Somehow I lost track. I'm extremely sorry. It will be complied with, my lord.
ಎಲ್ಲ ಆಯ್ತು. ಸೌಜನ್ಯದಲ್ಲಿ ಹೇಳ್ತಿದ್ದೆ, ತಮಾಷೆ ಮಾಡಿ ಹೇಳ್ತಿದ್ದೆ, ನಗುಮುಖದಲ್ಲೇ ಹೇಳ್ತಿದ್ದೆ, ಜೋಕ್ ಮಾಡಿ ಹೇಳ್ತಿದ್ದೆ. ನೋಡಿ 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 ನನಗೆ ಬೇಜಾರಾಗ್ತಿದೆ. Counsel for the appellant appearing through video conference. Once again, praise for time. As a final last opportunity, a week's time is granted, failing which the court may proceed to court. If not complete, 311. Finally, 1 week is
7. Charge number AM.
Small objection, the 50 rupees stamp ಹಾಕ್ಬೇಕು, ತಾವು ಈಗಲೇ ಪರ್ಮಿಷನ್ ಕೊಟ್ರೆ 50 stamp. ಎರಡು welfare stamp. IA ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ, IA for CD 10 ಗೆ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ. ಅದನ್ನ ಬರ್ದಿಲ್ಲ, ಆಮೇಲೆ 50 ರೂಪಾಯಿ ಸ್ಟಾಂಪ್ ಹಾಕ್ಬೇಕು ಅಂತ ಇದೆ. ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ರೆ I will do the municipal here.
at request of the learned counsel for the appellant. Matter is passed over to enable her to comply the office objection. Call the matter at 2:30 p.m.
Number 8, Satisha DJ.
Office objections regarding two office objections, sir. I have given submission, my lord. One is regarding the asking me to produce the
1 minute.
for
1 minute, 1 minute. Yes, please.
regarding the two objections, my lord. I have produced the annexure R, is the affidavit filed by the petitioner as a PW1 before the trial court regarding the condonation of delay. Condonation. There, because of the advocate filed died during the
1 minute. Annexure R.
Annexure R is the affidavit of the petitioner. Where
No, what is the office objection?
well, they asked me to produce the IA for condonation filed before the trial court. Regarding that, my lord, the advocate died, my lord. The advocate was representing, he died. So that's why at that time, I have produced the PW1 evidence itself, which discloses the statement regarding the condonation.
No, whether IA was filed in the trial court.
Yes, IA was filed.
Then are you not required to file a copy of IA here?
Asked the, I 2 weeks time and kindly granted, my lord, I produced.
200 rupees per day. Earlier peremptory order was passed in this matter.
Complained all other objections, my lord, regarding those two
And the excuse what you are giving is absolutely not at all coming near to the convincing point. Petition ಬಂದಿರೋದು ನೀವು, ಚಾಲೆಂಜ್ ಮಾಡ್ತಿರೋದು ನೀವು. ಅವ್ರು ನಿಮಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ, ಅದು ನಾಟ್ ಎನ್ ಎಕ್ಸ್ಕ್ಯೂಸ್. ಅವ್ರು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ತಗೊಂಡು ಹಾಕಿ.
ಅವರು ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ ಅಂತಲ್ಲ. The petitioner's advocate was representing them before the trial court is no more.
ನಿಮಗೆ ಪಾರ್ಟಿ ತಾನೇ ವಕಾಲತ್ ಕೊಟ್ಟಿರೋದು, ನೀವು ಪಾರ್ಟಿನ ಕೇಳಬೇಕು, ಅವ್ರು ವಕೀಲರನ್ನಲ್ಲ. Heard the submission of learned counsel for the petition. The submission regarding non-compliance of the two office objections which are still due for complaints is not convincing. Office objection sustains. Next time, learned counsel prays for 2 weeks time to complete office objection. Considering the fact that the appeal is of the year 2019 and earlier, a peremptory order was also passed in this matter on 2/9/2022, which is more than 1 year from now. As a final last opportunity, 10 days time is granted. However, imposing cost of rupees 500 payable by the petitioner to the legal services committee of this court within 2 days. Adanella Madi, failing which the peremptory order dated 2/9/2022 automatically comes into operation and the petition stands dismissed for non-compliance of office objection. However, with effect from 3/11. However, with effect from 6/11. Yes.
Non-compliance 6 times 9, Mallikarjun G, contractor.
The counsel for the appellant neither present physically nor through video conference. The perusal of the order could go to show that in this appeal of the year 2019, in spite of granting several and sufficient opportunities of not less than 6 times, the appellant has not complied of this objection. The office objection, which is single office objection, doesn't require much time to comply the same. However, for all these years, the appellant has not complied of this objection. On 17/7/2023, this court has made the following observation. In spite of the above, neither there is an neither there is any complaints of office objection, nor any reason is shown for non-compliance. This clearly go to show that the appellant is not interested in prosecuting the appeal and to comply of this objection. Hence, the appeal stands dismissed for non-compliance and for non-compliance of office objection and for non-prosecution. Yes.
Till number 10, Surya Prakash AM.
Single office objection, 9 office objections which are simple in nature. Mali. The perusal on 12/6/2023, court had made the following observation.
Till number 11, 7th time, non-compliance.
Apply within the course of. Comply within the course of.
If you complain the forenoon session, 500 rupees cost. Permission would be granted to comply office objection with the cost of rupees 500 payable by you to the legal services committee before forenoon session. All office objection to be complied with. That would be called at 2:30 PM. The learned counsel for the appellant submits that to comply the office objection during the course of the day. Next time, perusal of the order sheet would go to show that appeal is of the year 2019 and not less than 7 opportunities, including as final and last opportunity, were all being granted to him to comply with his objection. Hence imposing a cost of ₹500 payable by the appellant to the Legal Services Committee of this court in the foreign session and filing a complaint memo along with original receipt to that effect in the registry. He is permitted to comply with his objection within the foreign session of this court of today. Failing which, the court may proceed to pass appropriate order, including dismissal of the appeal for non-compliance as well for recovery of the costs. Call the matter at 2:30 p.m.
Order of matter still number 12, Sridhar DS.
Number 2.
Filing memo for dispensation of notice to R1 and R3.
R1 and
R3.
this today. Learned counsel for the appellant and learned counsel for respondent number 2 are physically present. Learned counsel for the appellant files a memo seeking dispensation of notice to respondent number 1 and respondent number 3. The perusal of the order sheet and the memorandum of appeal will go to show that the appellant has filed this appeal seeking enhancement of compensation. The notice was ordered upon the respondents as long back as on 11/10/2019. From the said date till today, that is for nearly 4 years, the appellant has taken time to take steps to ensure the service of notice upon respondent number 1 and 3. However, today he has come up with a memo seeking dispensation of notice to them, which you could have filed at the earliest point of time without taking the time of 4 years of the court. This would invariably burdens insurance to pay the interest on the enhanced amount if any during this said period of 4 years for no fault of insurance company. ಇದು ನೀವೇ ಮಾಡಬೇಕು ಈ ಸಬ್ಮಿಷನ್ ಕಣ್ಣಿಗೆ ನಿಲ್ತೀರಿ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅವರು. You are more friendly probably with the bar members than the insurance company. ನಿಮ್ಮ ಆರ್ಡರ್ ನಲ್ಲಿ ಲಾಸ್ಟ್ ರೋಸ್ಟರ್ 4 ಮ್ಯಾಟರ್ ನಾನು ಆರ್ಡರ್ ಮಾಡಿದ್ದೇನೆ denying the interest in your favor.
Insurance company
ಆ ಕೇಸ್ ನಂಬರ್ ಕೊಡೋದಲ್ಲ ನಾನು.
The examination against insurance company for MSD.
ఏంటంటే
The said period of 4 years for no fault of insurance company.
continue ಮಾಡಿ provided the liability is fastened upon the insurance company against whom the petition has already stood dismissed and will be impugned judgment. The impugned judgment has fastened the liability solely upon respondent number 1. If the notice to respondent number 1 is dispensed with, it is not known how the appellant could proceed in the matter. Yes, what is your submission?
The owner and the driver of the workplace expertise for the tribunal filed memo for dispensation of notice. Since owner and the driver of workplace expertise before the tribunal are filed.
Liability is fastened upon respondent number 1. You are seeking dispensation of notice to against respondent number 1. How can you maintain this appeal? despite the court specifically asking the learned counsel for the appellant as to how he could maintain the appeal in the absence of respondent number 1, against whom alone the liability is fastened upon by the tribunal, the learned counsel for the appellant is unable to convince the court in that regard. In that view of the matter, since the appellant himself has taken the risk of seeking dispensation of notice to respondent number 1 and 3, the notice to respondent number 1 and 3 stands dispensed with. Consequently, since in the absence of the respondent number 1, who is the sole liable person under the interim judgment, the present appeal cannot be maintained, the appeal also stands dismissed as not maintained.
फिर बता दें कल्पना में भी 20 issue ने कोड़ा correspondent 1
Take time to take steps to respondent number 2, my lord. It's a case where the MSP punishment of permission. Who is the owner of the alleged vehicle?
Why can't court deny the interest in case if you succeed in the matter?
My lord, twice I had taken steps, my lord, to the respondent number 2. To the same address, he was served before the lower court and he was placed ex parte. However, my lord, I had taken steps twice to the same address. Now I will file my applications, my lord.
You were the claimant in the tribunal.
Yes, my.
So it is for you to ascertain his correct, complete and present address.
They still
In
say
case
that,
if he has changed his address.
they still say that he's
Your
residing.
delay and you not taking steps within the reasonable time would unnecessarily burden the respondents in case if you succeed in the appeal.
My lord, the matter was listed on 14/3, my lord. I sought 2 weeks time. Then I took steps on 13.
You cannot wait for the court to list the matter. In this type of matter, say it is for you to take steps in the registry and get an order by the court by moving the matter at least to order for issuance of notice. For years together, 4 years.
On 33, I had taken steps, my lord.
Notice has been returned as insufficient address. Even thereafter, the matter was listed. You had taken time to do needful. Finally, time was granted. You have not done. So not entitled for interest. Take down.
14/3 it was listed, my lord. 22.
In August, it has come. Heard the submission of the counsel for the appellant. Whom you appear for?
First respondent.
The counsel for respondent number 1 is physically present. In this appeal of the year 2019, till today, the appellant has not ensured the service of notice upon respondent number 2, who is said to be the owner of the alleged offending vehicle. The appellant is the claimant whose claim petition for compensation in the case of an injury in a road traffic accident has preferred this appeal. The delay in ensuring the service of notice would unnecessarily put a burden upon the respondents to pay the interest for the delayed period also in case if the claimant succeeds in this appeal. Even though there is no fault of the respondent for not receiving the notice in time. Hence, a week's time as paid is granted, however, denying the interest from 14/3/2022 till notice is served upon respondent number 2 on the awarded amount provided if the appellant succeeds in this appeal. Yes.
Number 14, Gopal Krishnamurthy, B. Sishwanagowda for respondent number 3.
Respond number 2, you were close to.
Yes.
Please, that the respondent number 1, it is Nagar Jappa, who is none other than the husband of the appellant. He expired on 19/7/22. The appeal is abated against him. 19/7/2022 he expired.
For the submission of counsel for the appellant. Who submits that?
And I have taken steps against.
Respondent number 1 is the husband of the appellant and he died long back. As such, the appeal against him stands abated.
I have taken steps against
In
all.
of the same, the appeal as against respondent number one stands abated. Next line, if there is a law of infringement judgment, it doesn't show the name of the said. The Nagarajappa will be present with respondent number one hearing. Next line,
Steps against respondent number 2 I have taken in the morning.
interest should be denied.
Yes, please.
Though the learned counsel for the appellant submits that he has taken steps in the registry this morning as against respondent number 2. However, a perusal of the case file would go to show that the appeal is of the year 2019. On the till date, the appellant has not ensured the service of notice upon the respondent number 2. The consequence would be that the respondent number 2, upon whom alone the liability was fastened by the tribunal, would be unnecessarily burdened to pay the interest on the enhanced amount, if any, even for the delay period in the appellant taking steps against him to ensure the service of notice. The notice was ordered in this matter on 22/2/2019. That is more than 2 years, 7 months. In the above circumstance, it is ordered that the appellant is not entitled for the interest on the enhanced amount, if any, in this appeal from 22/2/2019 till the service of notice upon respondent number 2. Right, next then, registry to verify regarding the steps that have been taken by the appellant with respect to respondent number 2 and proceed further in issuing the notice without any delay.
Still number 15, Matsudan.
Sir, if not caught already.
Still number 15, Matsudan Ahmed.
Morning, I'll take a steps file. Also, okay.
The counsel for the appellant submits that needful has been done by him in the registry this morning. Still, the fact remains that in this appeal of the year 2019 till date, the appellant has not ensured the service of notice upon the respondent number 1. Though the notice was ordered on 16/7/2021 and the appellant had taken steps only once, subsequently he did not take steps thereafter, resulting in the respondent number 1 having remained unserved till date. In the above circumstance, in case if the appellant succeeds in this appeal, the respondent should be unnecessarily burdened with paying the interest for the delayed period of service of notice upon the respondent number 1 for no fault of them. Hence, it is ordered that the appellant is not entitled for the interest In case if he succeeds in this appeal from 16/7/2021 till the date of respondent number 1 is being served. Yeah.
Till number 16, Shivkumar P.
The concept of the financial measure present in the filling of the video conference. In spite of ordering issuance of notice on 15/6/2023, the appellant has not taken steps till date, which results in the respondents paying interest for the delayed period in service of notice upon them. Though there's no fault on their part. Hence, a week's time is granted. Hence, though a week's time is granted to the appellant to take steps, but it is ordered that the appellant is not entitled for interest on the enhanced amount in this appeal from 15/6/2023 till both the respondents are duly served with the notice. In case if the steps are not taken, register to list this matter on 2/11.
Till number 17, Santosh S. Kogi. Session.
Second respondent.
I apologize, my lords. My lords, I appear for petitioner. Week's time, my lords, kindly accommodate week's time to comply to take these steps, my lords. Same address is there, my lords, but even though it is not, my lords, we'll take the fresh steps, my lords.
From May till date, you have not taken step.
Yes. I apologize, my lords. We'll do it, my lords, 1 week accommodation.
The counsel for the appellant appearing through video conference placed for a week's time to do needful in the matter. The counsel for respondent number 2 is physically present. The result of the order sheet would go to show that the appellant is the claimant who has filed this appeal challenging dismissal of his claim petition by the tribunal. That being the case, even though the notice was That being the case, even though the notice was ordered long back in this matter, that is on 21/2020, but till date, the appellant has not ensured the service of notice upon the respondent number 1. On 31/5/2023 also, though it was directed to take first steps immediately, the appellant till date has not taken steps. Hence, it is ordered that in case if the appellant succeeded in this appeal, he is not entitled for interest on the annexed on the amount awarded, if any, in the appeal from the date 21/2020 till respondent number 1 is served.
Number 18, Vinod Gowda, yes, second draft for respondent 4.
Applicant, my lord. My lord, the R2 with the knowledge is not. Station R2 ಮತ್ತೆ notice 4 ಬಾರಿ ತಗೊಂಡ್ವಿ my lord. Station
What you are required to do in this matter for ensuring the service of notice upon R2 and R3?
paper.
Why you have not taken?
Taken form. June-ಅಲ್ಲಿ my lord, ನಾವು notice 4ನೇ ಬಾರಿ. June 2017, 2020. June 17, 2023 4ನೇ ಬಾರಿ ಕಳಿಸಿದ್ವಿ my lord. ಅದು ರಿಟರ್ನ್ ಆಗಿ ಇವಾಗ my lord. Notice.
ನಿಮ್ಗೆ ಜೂನ್ ನಲ್ಲಿ ನೋಟಿಸ್ ತಗೊಳ್ಳಿಕ್ಕೆ ಆರ್ಡರ್ ಆಗಿತ್ತೆ ಬೈ ನಾರ್ಮಲ್ ಕೋರ್ಸು. In case the data is not available, learned counsel for the appellant is directed to take suitable steps in that regard, not fresh steps. The court has meant that say you have to take substituted service of notice. You did not do that. ಯಾಕಂದ್ರೆ ನಿಮಗೆ ಬಡ್ಡಿ ಬರ್ತದೆ ಅಷ್ಟೇ. ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಅದಕ್ಕೆ ಮುಂಚೆ 3 ಸರ್ತಿ ಬಂದಿದೆ. 3 ಸರ್ತಿಯೂ ಬಂದಿದೆ. 4ನೇ ಸರ್ತಿ ನಿಮ್ಗೆ ಸಬ್ ಸರ್ವಿಸಿಗೆ ತಗೊಳ್ಳಿಕ್ಕೆ ಅವಕಾಶ ಕೊಟ್ಟಿದ್ದಾರೆ, ತಗೊಳ್ಳಿಲ್ಲ ನೀವು. But the submission of learned counsel for the appellant. Learned counsel for respondent number 4 is physically present. Even though the learned counsel for the appellant prays for a short accommodation to ensure the service of notice upon response or respondent number 2 and 3, however, as per his own submission, he had already taken steps for 3 times prior to 66/2023. And on all those 3 occasions, the notice sent to respondent number 2 and 3 has been returned unserved. The appellant has not taken steps for 3 times prior to 66/2023. And on all those 3 occasions, the notice sent to respondent number 2 and 3 has been returned unserved. The appellant has not taken steps for 3 times prior to 66/2023. And on all those 3 occasions, the notice sent to respondent number 2 and 3 has been returned unserved. It was thereafter on 16/6/2023, this court had directed the appellant to take suitable steps in case if the data is not available with respect to respondent number 2 and 3. Despite the same, the appellant has not shown inclination to take substituted service of notice upon unserved respondent number 2 and 3, who, even according to him, were placed ex parte before the Commissioner's court. Under the such circumstance, I am of the view that since the respondent should be unnecessarily burdened to pay interest for the delay caused by the appellant in ensuring this did. 10 days time has paid. However, by denying the interest on the enhanced amount of pennies from the date of ordering of the notice upon respondents in this matter, till respondent number 2 and 3 are served. It is ordered accordingly. 10 days time as paid is granted.
Bill number 90, Shiv Kumar P.
One bar 23. One bar 20. One appears for the learned counsel for the appellant, neither present physically nor through video conference. No reasons are forthcoming for his non-appearance. The perusal of the materials placed before this court, including the memorandum of appeal, impugned order, and IA 1/19 and 2/20, IA 1/19 and 1/20 would go to show that the claimant before the tribunal has filed this appeal seeking enhancement of quantum of compensation for the alleged death of her husband in a road traffic accident. MEC filed before the tribunal, the claim petition, UMC number 7253 of 2011 was filed before the tribunal in the year 2011, which came to be disposed of on 15/6/2016. However, the present appeal has been filed with a delay of 843 days, which is more than 2 years and a nearer to 3 years. Seeking continuation of delay, the claimant had filed IA 1/19 and section 5 of limitation. However, at a later date, the said IA came to be disposed of as not trust. Then IA 1/20, the later IA 1/20 was filed under the same provision of law, seeking the same length of delay of seeking the continuation of the same length of delay of 843 days in preferring this appeal. This court, after perusing the IA on 18/10/2022, 18/10, on 14/7/2023, directed the learned counsel for the appellant to file a fresh affidavit. However, till date, no fresh affidavit has been filed by the appellant. Further, the learned counsel for the appellant also has remained absent. Thus, from the year 2019 till date, the matter is simply pending before the court, showing no progress in the court, no progress in the matter. Despite the specific direction by the court, no better affidavit is filed with the applicant in IA 1/20. Perused IA 1/20 filed under section 5 of limitation act, seeking condemnation of delay of 843 days in filing the appeal. The affidavit accompanying the application is nothing but a replica of the affidavit of previous application. The previous affidavit filed along with IA 1/19. Though the deponent in the affidavit has stated that she was not keeping well for a few days and thereafter she was not keeping well for a few days and his advocate had changed his office, and that she has also misplaced his phone number. However, with great difficulty, she could able to establish contact with his counsel very recently. And only then, only thereafter, she could discuss the matter with him and prefer this appeal. Next line. The said reasoning, prima facie appears to be lacking bona fide, though she contends that she was bedridden. However, there is no details about the ailment or for what duration she was bedridden. No medical certificate is accompanying the application. Further, her contention that she had lost, her advocate had changed his office and she too had lost his telephone contact number is also uncorroborated with any document. The said advocate also has not filed his affidavit, nor there any material to show that there was such a change in his office and the appellant couldn't able to establish telephonic contact with him. Under the said circumstance, since the appellant has not made use of a sufficient opportunity given to her to file a better affidavit even after she withdrawing a similar application earlier, and the appellant has not made use of the same, I do not find any reason even for issuing the notice upon the respondent on the IA. Accordingly, IA 1/20 stands dismissed as devoid of reasons even to order notice upon it. Consequently, the appeal, which is barred by 843 days in time, stands dismissed as barred by limitation. Yes.
Till number 20, NR Rangegoda. Still number 20.
Less time to file.
Counsel for the appellant who is physically present, prays for 2 days time to take steps. Perusal of the order sheet would go to show that this court had already denied him the interest for 1,123 days while following a 2/2022 on 6/7/2023 and had ordered for issuance of notice. In spite of the same, the appellant has not taken steps till date. This itself would go to show that the appellant is not diligent in pursuing the matter. Hence, it is further ordered that the appellant, in case it succeeds in the appeal, is not entitled for interest. On the enhanced amount, if any, in this appeal. Apart from 1,123 days till the date of the respondents are being served. Yes.
Number 21, Raghu R. Ashok N. Patil for respondent number 2.
You have taken steps today. After 3.5 years. After 3.5 years. Notice was ordered on 22/2020. Steps ಯಾವಾಗ ತಗೊಂಡಿದ್ರಿ ನೀವು?
April 2022.
3/2.
2022. Paid on.
The counsel for the appellant is physically present and submits that he has taken first steps this morning in the registry. Next line, he further submits that on the previous occasion, he had taken steps on 3/2/2022 The perusal of the order sheet would go to show that though the learned counsel for the appellant claims that no steps were taken on 3/2/2022, however, the notice was issued by the registry to respondent number 1 only on 18/4/2022. Thus, 1.5 months with a delay of 1.5 months after taking steps. However, the return of the notice has not served with the postal share address he left has been recorded in the proceeding sheet by the registry only on 17/10/2023. That is more than 1.5 years later. It has been repeatedly observed by this court previously also in several of the matters, particularly in MEC cases. The registry is causing inordinate delay, either in issuing the notice or listing the matter before the appropriate bench by recording the service or non-service of notice upon the respondents, which in turn burdens the respondents to pay interest for the delayed period also, in case if the appellant succeeds in their appeal. Added to that, the appellants who would be expecting the order at the earliest, particularly in the case of enhancement for compensation or for seeking compensation by challenging the judgment of dismissal of their claim petition, would be denied the justice, it would be denied the timely justice. Previously, the memos were being issued for which the registry used to submit a routine reason of alleged pressure of work, when in fact the said reasoning was not convincing. This is one more such case where even after dispatch of the notice for 1.5 years, the registry did not list the matter. Learned Registrar General is directed to place this observation before the Honorable Chief Justice of this court for his information and suitable direction in this matter. Next line, registry. Since the appellant submits that needful done, registry to verify and proceed.
Serial number 22, Ravisankar Shastri, BC Sitaram Rao, correspondent number 2.
Three to 5 years, 4 claimants, claim petition was dismissed. For relief is claimed.
Heard the submission of Learned Counsel for the appellant on the memo dated 27/2/2020 filed by him seeking dispensation of notice to respondent number 1, 3, 4, and 5. In view of the memo supporting submission, the notice to respondent number 1, 3, 4, and 5 stands dispensed with, however, the consequence and risk of the appellant. Or to copy other side serve ಮಾಡಿದ್ದೀರಿ.
To quote, they are served. 72 days, days.
The Learned Counsel for the appellant submit the through court the respondent number 2 has been served with a copy of I1/90. Despite the same, the respondent has neither filed objection. Despite the same, the respondent number 2 has neither filed his objection if any to set IA1/19 nor appear in the matter today.
I appear for respondent number 2.
Hence, it is taken that objection to the said IA is not filed. Peruse the IA1/19 filed under section 5 of Limitation Act seeking continuation of delay 72 days in filing the appeal. Considering the reasons shown in the affidavit accompanying the application, where the deponent has expressed the effort made by him in filing the appeal and explain the delay with reasons, I am of the view that sufficient cause for the delay has been shown. Accordingly, IA1/19 stands allowed and the delay of 72 days in filing the appeal stands condoned.
The respondent number 2 is
Call for LCR. Yes.
Till number 23, Commission.
Was this matter earlier sent to Lok Adalat? Any settlement was reported or attempted to report?
But we have.
There are counsel for the appellant and respondent number 2 are physically present for both sides on the memo dated 27/2/2020 filed by the appellant seeking dispensation of notice to respondent number 1. In view of the memo submission made by both sides, the notice to respondent number 1 stands dispensed with as plain. However, the consequence and risk of the appellant. IA for delay.
Delay may be condoned, not a date of interest, 78 days.
The
78
Learned Counsel for the respondent number 2 submits oral objection to IA1/19, which is filed by the appellant seeking under section so and so seeking condonation of delay of so and so days in filing the appeal. Considering the reasons shown in the affidavit accompanying the application, I am of the view that the applicant has shown the sufficient cause for the delay. Hence, IA1/19 stands allowed and the delay of 78 days in filing this appeal stands condoned. Call for a fifth here if not already called.
Till number 24, O Mahesh.
Appear for the appellant, my lord. I request the court, my lord, to peruse the order dated 29/8/23, my lord. some confusion as to the, my lord, the statutory check which has been deposited by the appellant insurance company. A memo was filed, my lord, on 12/7/23, giving the particulars. Earlier, my lord, the office, my lord, said that it is in respect of another MFA. I gave the, my lord, the bank particulars also. Unfortunately, my lord, the officer of the insurance company who presented the, my lord, check in person retired, and he had not kept, my lord, the appointment in the file. However, my lord, we were able to furnish, my lord, the particulars in memo, my lord. You have to kindly see in a tabular form, my lord. We have furnished this thing, and court directed, my lord, to verify with the accounts branch. I personally visited the, my lord, the scrutiny branch 2-3 times, and I apprised him also the, my lord, regarding these particulars to verify with the accounts branch.
Yes, despite all the exercises, say you were required to deposit the statutory amount since you could not able to demonstrate before the court that you had deposited this said amount.
Yes, my lord, we will kindly look into the memo, my lord, which I have filed. Appeal, my lord, is filed on 9/9/2019. Earlier, my lord, the office said that the particulars given was in respect of another MFA, my lord, 9/83 of 2019, and the check was realized on 4/2/2019. But I have given, my lord, the particulars of the bank furnished by the appellant insurance company in the tabular form. And to quote also
Mr. Counsel, the details of the alleged deposital of the amount you have given through your two memos.
Yes.
11/7/2023 and 12/7/2019.
Yes.
Your first memo was of the year 2019 and subsequently the second memo was the latest one, 11/7/2023.
Yes, my lord.
In both the memo, you have given the particulars of the alleged payment made.
Yes.
With respect to the statutory deposit.
Yes.
Giving the check number and the name of the bank also.
Yes.
The check number has been verified by the account section and it has mentioned clearly that the said check amount, the said check bearing number 165950 was with respect to another MFA filed by you only as a counsel for insurance company. And they have given the said MFA number also as another MFA bearing number 673 of 2019.
That is
not this MFA. Therefore, if you have made double payment in the said MFA, withdraw the one payment of statutory deposit. But according to registry, the said check towards the alleged statutory deposit has been, though realized, has been credited to MFA 6763 of 2019. This present appeal is MFA 7537 of 2019.
Well, this information was not given to me, my lord. Now it is posted.
This information was given to you in the hearing previous to the previous date of hearing. What I am reading is with a reference note put up by the registry prior to the previous date of hearing. After that detailed note put up by the registry, one more time the case came up before the court for hearing, there the time was granted to you.
My lord, may I request the court, my lord, to pass an order so that I can pass it on to the, my lord, the company to take necessary steps, my lord.
No, why should we pass an order? I can dismiss the appeal for not depositing statutory deposit. Swami, ನೀವು ಮಾಡಬೇಕಾದ ಕೆಲಸಕ್ಕೆ ಕೋರ್ಟ್ ಯಾಕೆ ಆರ್ಡರ್ ಮಾಡಬೇಕು?
What has happened?
ಕ್ಲಿಯರ್ ಆಗಿ ಅಬ್ಸರ್ವ್ ಮಾಡಿದೆ, ನೀವು ಕೊಟ್ಟಿದ್ದೀನಿ ಹೇಳೋ ದುಡ್ಡು ಇನ್ನೊಂದು ಅಪೀಲ್ ನಲ್ಲಿ ಮಾಡೋದು ಬಿಡೋದು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿಗೆ ಬಿಟ್ಟಿದ್ದು, ಅದಕ್ಕೆ ಆರ್ಡರ್ ಯಾಕೆ ಬರ್ತದೆ?
At least, my lord, 10 days time may be given, my lord. I will convey the message to the, my lord, company.
ಅದನ್ನ ಕೇಳಿ ಕೊಡುವ.
Yes.
ಎಲ್ಲದಕ್ಕೂ ನೀವು ಕೋರ್ಟ್ ಹೇಳಿದೆ ಅಂತ ಹೇಳಿ ಮಾಡಿ ನೀವು ಕೈ ತೊಳ್ಕೊಂಡು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿನು ನಾಳೆ ಆಡಿಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಬರಬಾರ್ದು ಅಂತ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಅಂತ ಬರೆದ್ರೆ ನೀವಿರೋದು ಶಾಸ್ತ್ರೀಯವರ ಕೋರ್ಟಿನಲ್ಲಿ.
What has happened is the officer has retired. That's the main problem.
ಆಗಿದೆ, ಬೇರೆದಾಗ್ಲಿ. Officer may come and go, but the establishment remains.
Yes, my lord. In the accounts, my lord, these are the particulars obtained.
Let's have the submission of learned counsel for the appellant who is appearing through video conference. When the court brought to his notice the endorsement dated 27/9/2023 put up by the registry, clarifying the position that the alleged payment said to have been made through check number 165950 of Deutsche Bank was not towards this appeal and not towards the present appeal, but it was towards MFA 6763/2019, which is filed by the very same counsel appearing for the appellant in this appeal, the learned counsel submits that the said information was not to his notice as such. He would take up the matter with the appellant insurance company and ensure the deposit of the statutory amount of statutory deposit within 2 weeks from today. Needless to say that after the office endorsement dated 27/9/2023, one more hearing date was intervening, and the matter did appear before the court on 5/10/2023, when 1 week time was granted to the appellant to do needful. Next time, however, considering the submission made today as a final last opportunity, 2 weeks time is granted to the appellant to deposit the statutory deposit amount, failing which the court may proceed to pass appropriate order, including dismissal of the appeal for non-compliance of the deposit of the statutory amount.
Please.
List the matter on 15/11.
Please.
Yes.
Bill number 25, Manjunath H.
Good. The counsel for the appellant who is physically present, writes a memo, not present the present appeal. In view of the memo supporting submission, the appeal stands dismissed as not present. The surveying guy does not survive. Yes.
Bill number 26, Janardhan Reddy.
At the request of the learned counsel for the appellant, 2 weeks time as paid is granted to do needful.
Bill number 27, Vijay Krishna Bhatt.
One has address not there, but I will take fresh steps, and also take a liberty to serve the trial court counsel for our
Yes, please.
Our second respondent. Notice has come back as the address is not there. But I will take first steps, but I also seek liberty to serve the counsel appearing in the trial court also.
Where is the material to show that the present respondent number 2 was being represented by his counsel in the trial court?
The third defendant before the trial court. Has filed a written statement also. Is contesting the matter.
Third defendant in the trial court is the second respondent here.
In this, written.
But the request of the learned counsel for the appellant who is physically present, 10 days time is granted to ascertain the correct, complete and present address of unserved respondent number 2 and take first steps upon the said respondent. As prayed for by the learned counsel for the appellant is also permitted to take notice by hand upon the learned counsel for the second respondent hearing in the trial court, where he was a faith in a way the present second respondent is shown to be the third defendant, occupying the process and being needful. The notice is required to be served by hand, which is in addition to the service of notice in the normal course, and file a complaint affidavit along with acknowledgement of filing in the registry within the said period of 2 weeks. Yes.
Hearing on implemented applications number 28, Vakuntha B. Pradeep correspondence 3, Art sir.
Correspondent number 2. Right. Here for application of notice to respond number 1 and 2 is back. To respond number 2 is third. Permitted to respond number 2 by paper copy. Notice to respond number 1 and 2. Notice to respond number 2 is served, my lord. I filed application taking steps to respond number 1 and 2 through by way of paper publication. That my lord, I may be permitted to take notice to respond number 1, my lord, since the notice to respond number 2 is served.
What happened service of serving the notice in the normal course?
Not served.
With what reason the notice has been returned? What prompted you to take sub-service of notice?
Even in the trial court it was served, but my lord, in the high court it was given 2 times.
What prompted you to file an application seeking substituted service of notice upon unserved respondent?
The waiting service.
Unless you mention that in your application doesn't deserve to be allowed at all.
He is awaiting to take the notice of the case, my lord.
The postal sheriff says that no such addressee or addressee left. You yourself has mentioned both.
Trial court, my lord, notice to respond number is number 1 is served. He was represented before the trial court, my lord.
No cover was received with respect to respondent. Respondent for 1 year. First time the notice survival cover with it. The submission of the council for the offering is on who is physically present on a 2/2022. Therefore, notice to respondent number 1 and 2 by way of paper publication. The learned council submits. But since the respondent number 2 has already been served but remained unrepresented, so is not trust the application as against respondent number 2. Next one, very good. 2/22. In the affidavit accompanying the application, the deponent has stated that the respondent number 1 and 2 are residing in the very same address shown in the cost statement. So the appeal, however, they are evading, intentionally evading receiving the notice. The postal shara shows that address is not known. Under the said circumstance, when the present appellant as a claimant in the tribunal himself has stated that the respondent number 1 is residing in the very same address, but however, at least risk the I under consideration be allowed. Hence, IA 2/22 is allowed in part with the following conditions. 1. Since IA is filed even as against respondent to the 2 or 2 against whom the notice has already been served, a cost of ₹1,000 is imposed upon the appellant. Payable by the appellant to the Legal Services Committee of this court within a week from today, and to deposit a complaints memo along with original receipt to that effect in the registry within the set time. Two. The IA is allowed in part only as against respondent number 1. But with the condition that in case if the respondent number 1, after his appearance claiming the appeal, convinces the court that he has not been residing in the address shown in the cost title as on the date of the filing of the memorandum of appeal, then the appellant would not be entitled for any interest on the awarded amount, provided if he succeeds. For not approaching the court with clean hand regarding the address of respondent number 1. Next time, register to proceed further in the matter. In approving the draft only after satisfying the payment of the cost order. The appellant will furnish draft register the format date. Date of publication on or before 8/11. Date of appearance. Hearing 12/12. Yes.
Number 29, Pradeep B. Recall P. Pavan, B. Shivanagoda.
Then filing appeal madam. One by one.
Heard from both sides. Also from both sides, physically present, heard both sides on 8/19. Counsel for the respondent number 1 and was published there no objection to allow 8/19. Another period of the law to format actually allowed to be conjoined LCR.
And one submission. TCR my lord. TCR required.
Order ಮಾಡಿದ್ದೀನಿ.
My lord one submission. Actually cross appeal is cross I filed a cross appeal man. MFA CROP 36/2022.
Which respondent were appearing?
Appeal for the respondent number 1 my lord.
When counsel for respondent number 1 submits that against the very same impugn judgment, MFA crop number so is filed and placed to list both the appeals, both the matters together, register to verify and give name.
Number 30, Ramesh Kechi, SV Sudhakar Reddy Pavan.
Delay.
At the submission of legal counsel from both sides for physically present among the 1/19, built on section 4 proceeding. So. Both sides reiterate the contention taken up by them in their application, the statement of objection respectively. The deponent in the affidavit accompanying the application has pleaded in ignorance of knowledge. The respondent number 1 in his objection has contended that no sufficient cause has been shown expelling the illegal. In the light of the above, after hearing the submission, I am of the view that considering the nature of the appeal, the delay we find out, however, by denying the interest on the answered amount, if any, in this appeal, for the period of delay of 1,035 days, ordering accordingly a 1/19 stands alone. Call for each year if not already found.
Number 31, K. Prasanna Shetty.
At the submission of land counsel for the appellant who is physically present. Respondents, those served have remained absent as such. No objection has been filed from the respondents to a 1/19. Service day 1/19, filed in section so and so, seeking so and so. Consider the reason of the relevant format of IALO, LCR. Here,
Serial number 32, Abdul answer.
Serial number 32 appear for the advocate and record, my lord. 261 days delays are there.
for the submission of land council for the increase appearance in video conference and IA 1/19. Filed under so and so for so and so. Land council for R3 is physically present, however, he has not filed his wakalat.
Today they have given the appeal memo
And the
by 11.
matter as admittedly. R3 has not filed his subsection to you 1/19. Various days. Considering reason number 11 party. IA allowed no interest.
Serial number 33, Chetan B. Mohan Kumar T for respondent number 2.
There's a delay of 62 days. Of the vehicle. As per the order passed with the MSCT, the insurance companies and liability. But I have also sought for the dispensation of the notice brought against transport.
Current council from both. Third one, memo dated 4/2/2020. In view of the memo on supporting submission in the appellant. Notice to respondent number 1 stands dispensed with, however, the consequence in respect to appellant. Next, A1. Third both side. Format has followed delay and LCR.
34, Somsekhar KM.
Or seeking dispensation of notice to respondent number 2. File the memo. The council for the appellant is physically present, files a memo seeking dispensation of notice to respondent number 2. Memo. In view of the memo on supporting submission, notice to respondent number 2 stands dispensed with. It means that the files a memo will reach it. First, the submission, if you notice to the respondent, both on the main appeal and on the files a memo, dispensed with. United India Insurance Company.
Respondent number 1, United India Insurance Company Limited.
appellant to pay the
May I
necessary.
take notice, my lord?
Yes, Learned counsel. Shri. Vijay Kumar. Appeals. ನೀವು ಯಾರೋ ಶಟ್ರ್ ಮೊಬೈಲ್ ಇಂದ ನೀವು ಚೆಕ್ ಇನ್ ಆಗ್ತಿದ್ದೀರಿ.
I am sorry, my son.
ನಾಮ ಬದಲಾವಣೆ.
I am sorry, my name changed.
Your name changed.
Yes, my lord. That is my son name, my lord. I am sorry.
Learned counsel Sri Sons appearing through. Also takes notice for respondent number 1. The appellant to furnish. Or copy serve ಮಾಡ್ರಿ. ಅಯ್ಯನ ಮೇನ್ ಅಪೀಲು. To furnish copy of memorandum of appeal impugn judgment and copy of IA 1/90 to the said learned counsel for respondent number 1 within 3 days from today. The respondent number 1 to file their objection if any to IA 1/19 within 2 weeks from the date of service of copy of memo of appeal and IA to them. Within 10 days from today, within 2 weeks from today, the counsel for appellant number, respondent number 1 to 5 is wakalat in the register.
Still
Or
number,
LCR if not already filed. Yes.
still number 35, Somshankar came.
And maybe.
Memo file ಮಾಡಿ. Yes, ICICI ಕೂಗಿಸ್ರಿ.
Respondent number 1, ICICI Lombard Generations Company Limited.
Same order ಮಾಡಿ learned counsel advocate ಹೆಸರು ಚೇಂಜ್ ಮಾಡಿ R1 ಕಾಪಿ ಕೊಡಿ. ನೀವು ಒರಿಜಿನಲ್ ಕೊಟ್ಬಿಡಿ ಆಮೇಲೆ ಒಂದು ಕಾಪಿ ಒರಿಜಿನಲ್ ವಾಪಸ್ ಇಸ್ಕೊಳ್ಳಿ ಅವ್ರನ್ನ ಕಾಪಿ ಕೊಡಿಸ್ತಾರೆ ನಿಮಗೆ. ತಗೊಳ್ಳಿ learned counsel ಶ್ರೀ ಪ್ರದೀಪ್ Patnawar takes notice for R1 ಅದನ್ನು ಹಾಕಿ receipt of the copy of memorandum of appeal and IA 1/19 for 2 weeks time to file objection if any to said IA 1/19 and wakalat for respondent number 1. Time as trade is granted. All for LCR is not already. Yes.
Still number 36, Somshankar came.
My lord, this matter is connected with MFA 3614/18 filed by BMTC. FSAA has filed this appeal. You asked me kindly show his name. BMTC appeal.
Against the same impugned judgment.
Please, my lord. MEC 1325/17.
You are there for the appellant in the connected matter?
No, my lord. FSAA is there.
Learned counsel for the appellant is physically present and submits that against the very same impugned judgment, one more appeal bearing number MFA number so and so is pending, filed by the present respondent and being represented by learned counsel Sri so and so. Action. Issue notice to the respondent. The main appeal as an IA 1/19. Learned counsel Sri so and so, same advocate, takes notice for the respondent. Appellant to furnish the learned counsel for respondent the memorandum of copy of appeal, IAG, etc. ವಕಾಲತ್ತು ಉಳಿದ ಫಾರ್ಮಲ್ ಹಾಕಿ 2 weeks LCR. Yes.
Still number 37, Bhanu, HN.
United India.
Yeah.
ಅವರಿದ್ರು ಸರ್ವ್ ಆಗಿದೆ ಕಾಪಿ ಹಾಕಲಿಲ್ಲ. The counsel for the appellant neither present physically nor through video conference. United India Food.
Respondent number 2, United India Insurance Company Limited, Tumkuru.
The respondents do serve have remained unrepresented. No objection is filed from by the respondents for IA 1/19. Used. IA 1/19 filed by the appellant and so and so seeking so and so. In the affidavit accompanying the application, the deponent has stated that due to the injuries suffered by him in the accident, he could not contact his counsel in time. The said reason given in a sworn affidavit has not been denied or disputed from the other side. Hence, considering the reason shown on the nature of the appeal, I am of the view that the applicant has shown sufficient cause explaining the delay. As such, IA 1/19 stands allowed and the delay of 286 in filing the appeal stands condoned. Call for it is not already called. Yes.
Bill number 38, A. Sampath.
Yes, HDFC Ergo.
Respondent number 1, HDFC Ergo, Generation.
I will take notice, my lord. I will take notice first.
For the submission of the counsel for the appellant who is physically present. Raise the memorandum of appeal and IA. Issue emergent notice to the respondents, both on the main appeal and on IA 1/19. Learned counsel Sri Vijay Kumar appearing through video conference. Munidalla takes notice. Sorry, copy serve madi within 3 days. Till 2 weeks to file objection if any and wakala.
Much of this.
Bill number 39, Sripad Shakri, A. Krishna Swamy, for respondent number 2.
I am for appellant. Claimant's appeal. There is a 281 days delay, my lord, in filing the appeal.
IA.
Delay could be cut.
Counsel from both sides present. For the both side on IA 1/19. Delay condoned, no interest for the delay period of 281 days. LCR if not called, call for LCR. Yes.
Bill number 40.
Lord appeal has been filed. Not with a delay in filing the appeal. 120 days. not filed any objection to the application. And also I have filed application for production of additional documents under order 41/27. For which also not objection as on today.
Damages,
Damage caused to the
building and the goods.
please.
Respondents, those served who have not filed their objection in killing to IA 1/19. Heard on IA 1/19. From the council. Council for the applicant is fiscally present. If there is a format of it. I allow delay control LCR. Respondents to file their objection in any or IA 2/19.
Court appeal is filed arising out of
Same judgment.
common.
Counsel for the appellant further submit that arising out of common judgment. One more appeal bearing number so and so is pending. Other format is happy connected with.
Yes. Till number 41, Satish Chandra R. Dear Malati for respondent number 2.
Management of the compensation amount. The delay of 46, the highest allowed. Case number 10.
Present to forward maybe. I allow delay control no interest. Yes.
Till number 42, Ashok Kumar City K.
Days due to poor financial conditions, the applicants, but that is no.
United India.
Respondent number 1, United India Insurance Company Limited.
I will take notice.
I take notice for the.
Claim petition against insurance company dismissed.
There on liability, there is.
Emergent notice. And main appeal and IA. Learned counsel, receipt kudi, that's it. So physically present and accept notice for respondent number 1, or copy kudi.
I have to file my objection to the.
Like, you tagaltiddare notice idರಲ್ಲಿ.
Please, madam.
SV Hegde ತಗೊಂಡ್ರು.
Please, madam. Please.
ಕೊಡಿ, ಆಮೇಲೆ ಅವ್ರು ನಿಮ್ಗೊಂದು ಕಾಫಿ ಕೊಡ್ಸಿ ಕೊಡ್ತಾರೆ. ಕಾಫಿ ನಾವು ವಾಪಸ್ ಒರಿಜಿನಲ್ ಇಲ್ಲ, ಆಮೇಲೆ ನಾನು ಕಾಪಿ ಮಾಡಿಸಿ ಕೊಡ್ತೇನೆ ಅಂದ್ರೆ ಅದು ಮತ್ತೆ ಇಮಿಡಿಯೇಟ್ ಆಗುವ ಕೆಲಸ ಅಲ್ಲ ಅದು. Acknowledge the receipt of the copy of memorandum of appeal, interim judgment and IAS ಅದೆಲ್ಲ ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ ಹಾಕಿ. To process and furnish copies in the registry for service of emergency notice. So 2, 2 to 6 during the course of the day. ಇದು ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ ಹಾಕಿ. ಉಳಿದವರಿಗೆ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದೇನೆ ಇವತ್ತೇ ಕಟ್ಟಿ, ಡಿಲೇ ಮಾಡಬೇಡಿ. ಒಂದ್ಸತಿ ಡಿಸ್ಮಿಸ್ ಆಗಿರೋ ಮ್ಯಾಟರ್ ಇದು. ವಿತಿನ್ ಎ ಡೇ ಫ್ರಮ್ ಟುಡೇ ಅಂತ ಮಾಡಿದ್ದಾರೆ. LCR.
Serial number 43, Divyatej HN. Respondent number 3, HDFC Airco, General Insurance Company Limited.
I will take notice for HDFC.
ಯಾರು ತಗೊಳ್ಳಿ. ಅಲ್ಲ, ಅವ್ರು ಹೆದರ್ಸಲ್ಲ ನಿಮ್ಮನ್ನ. Emergent notice. Learned counsel Sri Pradeep takes notice for our 3. ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡಿ. ಉಳಿದಿರೋದನ್ನು ಫಾರ್ಮ್ಯಾಟ್ ನಲ್ಲೇ ಹಾಕಿ. ಉಳಿದಿರೋ ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ ನೋಟಿಸ್ ಈಗಲೇ ತಗೊಳ್ಳಿ. 4 ವರ್ಷ ಡಿಲೇ ಇದೆ. ಸೊ ಸ್ಟೆಪ್ಸ್ ಇವತ್ತ ತಗೊಳ್ಳಿ, ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡಿ, ಅಬ್ಜೆಕ್ಷನ್ ಇದ್ರೆ ಹಾಕಿ. ಎಸ್
44 Chandrasekhar R. Respondent 1 KSRTC.
I will take notice for cases.
Yes. Learned counsel Sri Vijay Kumar takes notice for respondent ಮಾಡಿ within 3 days copy to be furnished. 2 weeks objection ವಕಾಲತ್ತು. Yes. Yes.
Number 45 A Krishna Swami.
ನೀವ್ ಯಾಕೆ ಲೈಬಲ್ ಅಲ್ಲ?
Bouncing of check. Premium fee.
For the submission of learned counsel for the appellant. Issue emergent notice to the respondents both on the main appeal and on the appellant to pay the necessary process and furnish copies in the registry if not already done within a day from today. LCR. Yes.
56 Rangegoda NR. Respondent number 1 Reliance General Insurance Company Limited.
Respondent number 1 Reliance is the reliable in the.
Yes.
I will take notice for Reliance.
Emergent notice. R1 Vijay Kumar. To furnish copies of the 3 days after 2 weeks to file objection, etc. Process to R2 to be paid within a day from today. LCR. Yes.
47 Harish Kumar MS.
What's up?
Yes, sir.
Impute proceedings is that melo.
Emergent notice. Process ಕಟ್ಟಿ ಇವತ್ತೆ ಹಳೆ ಅಪೀಲು 4 years ಆಗಿದೆ. LCR.
Number 48 Pramod Toda TP.
My lord, I am for the appellant in this matter, my lord. My lord, I am for the appellant.
Your nickname is iPhone, huh?
My lord,
You are not showing your face also. You are displaying only your phone.
my lord, it is technical problem, camera. It's
Technical problem ಆಗ್ತದೆ. ಕೋರ್ಟ್ ಹಾಕಲ್ದೆ ಬ್ಯಾಂಕ್ ಕಟ್ಕಲ್ದೆ ಟೆಕ್ನಿಕಲ್ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ.
sorry, apology, my lord, apology, my lord.
ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ತೇನೆ ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ 2:30ಗೆ.
Please, my lord.
The matter stands passed over at the request of the 11th council. Call the matter to the Supreme.
Bill number 49, G. Lakshmi Rao, Sangamesh.
There are more deposit. Otherwise. People just have to.
This is closed on. This was already allowed on 10/2020. One of pending IA and proposed IA 1/20. The combination proposed. Earlier, Allah. Okay. Number 23. For transfer of amount and the first file. Transfer of amount to whom? You may have to file a fresh IA and IA 2/23. It is totally bereft of any details. How much of amount is deposited, by whom it is deposited, where it is deposited, under which Q receipt or any other document it is deposited, nothing. ಏನೇನೆಲ್ಲ ದುಡ್ಡು ಇಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟು ನಂಗೆ ಕೊಡ್ರಿ. ಆ ಪಾಟಿ ಸುಲಭ ಸಾಧನಕ್ಕೆ ಒಗ್ಗುವುದು ಕಷ್ಟ. ಅಟ್ಲೀಸ್ಟ್ ದುಡ್ಡು ಬೇಕು ಅಂದ್ರೆ ಎಷ್ಟು ದುಡ್ಡು ಬೇಕು, ಯಾರು ಇಟ್ಟಿದ್ದಾರೆ, ಯಾವಾಗ ಇಟ್ಟಿದ್ದಾರೆ, ಎಲ್ಲಿ ಇಟ್ಟಿದ್ದಾರೆ, ಅದಷ್ಟನ್ನಾದ್ರೂ ಬರಿಬೇಕು. Yes. The counsel from both sides. The counsel for the applicant in IA 2/23. Peruse IA 2/23, which lacks the basic required details like the quantum of the illicit deposit, by whom it is deposited, the date of the deposit, the Q receipt number is given. Next, and counsel for the applicant in IA 2/23 submits that would not press IA 2/23, however, seeks liberty to file a fresh application, reserving him the said liberty to be exercised if desired so within 3 weeks from today, comma, IA 2/23 stands to disposed as an article. Detail put haki ಇನ್ನೊಂದು application ಬೇಗ ಹಾಕಿ ಲೇಟ್ ಮಾಡಿದೆ. Yes.
Remaining matters, bill number 50, Suresh S. T. Seshgiri Rao for Kevata respondent 7.
One minute. 1 minute.
Let notice go to the respondents.
Meaning the response filing no for dispensation because trial board is based on.
This one.
Respond number 2 as the statement, but she has not filed any objections to that this application.
Council property. Petitioner is physically present and files a memo seeking dispensation of notice to respondent number 1 to 6. At the submission of Lord Council for the petition, who is physically present, issue emergent notice to the respondents. Next to 11th Council also files a memo. There is the memo for submission. Notice to respondent number 1 to 6 can be dispensed with, however, the consequence and risk of the petition. The petitioner to pay the necessary process and furnish copies in the registry. The for notice to the other respondents who are not being represented in this petition as it. The needful to be done within a week from today. Yes.
Admission matters number 52, Suresh M. Lathur, Rajendra Hegde Mulkhand for respondent number 2.
For the appellant, my lord. It is a claimant's appeal, my lord. For enhancement of compensation, this claim appeal has been filed. It's a case of injury, my lord. The accident has taken place.
1 minute. Yes.
One submission, my lord. I'm praying for a week's time.
Yeah,
I had some inconvenience today morning, my lord.
ಏನಾಯ್ತ್ರಿ?
File has been.
ಬ್ರೇಕ್ಫಾಸ್ಟ್ ಸರಿ ಕೊಡ್ಲಿಲ್ವಾ ನಿಮಗೆ?
Just a week's time. Can be taken any day.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಏನೋ ಸ್ವಲ್ಪ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇದೆಯಂತೆ.
Sir.
Counsel for the appellant is the appellant is appearing through video conference, submits that he is ready to proceed further in the matter. However, learned counsel for the respondent who is physically present, citing some reason of inconvenience, prays for a week's accommodation. In this time of credit is granted. Number 4 ಏನಾಗಿದೆ ಗೊತ್ತಿಲ್ಲ. ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ 2:30 ಬನ್ನಿ.
First one matters. Serial number 4. G. Shastri.
Take the appeal for the petitioner. Withdraw my application. Become infractor.
School. Called again in the afternoon, the counsel for the petitioner who is physically present. Files a memo seeking dismissal of this petition as withdrawn. In view of the memo supporting submission, the petitioner stands dismissed as withdrawn. Yes.
Serial number 7. Chardamba.
Called again, learned counsel for the appellant submits that all the office subjects are complied with, registered to verify and proceed further.
Serial number 11. Say, Hassan Rasvi.
11. Counsel for the, again, counsel for the appellant submits that all the office objections are complied with, registered to verify and proceed further.
Serial number 48.
And for the petitioner in this matter, Your Honor. My lord, I am for the appellant in this matter. 359 days delayed is there.
United India.
Respond number 1. United India Insurance Company Limited.
For the emergency. both on the main appeal and the necessary process and furnish copies in the registry within day from today. Yes.
Continuation of list, admission matter serial number 53, O Mahesh, D Sadashiva for responding one, connected matters.
One minute. Yes, please.
Filed by the. It does not contain the statutory deficit particular for the blank. Deficit of 20,000 crore, section number 10. This petition, this appeal memorandum contains nothing about this payment of the statutory deposits. One.
You are for the claimant.
Yes.
You are for the claimant.
Claimant.
You are holding the memorandum of appeal in MFA number 19 of 19, right?
Yes.
What is written below the cost title?
deposit of rupees 25,000 through check number dash dash dated dash dash in respect of the Registrar General High Court of Karnataka is made in compliance of section 173 of Revenue Act.
So statutory deposit detail he has mentioned.
ಇಲ್ಲ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ ಚೆಕ್ ನಂಬರ್ ಮತ್ತೆ ಇದು ಬ್ಲಾಂಕ್ ಇದೆ ಅಷ್ಟೇ ಅದೇ ಐ ಡೋಂಟ್ ನೋ ಚೆಕ್ ನಂಬರ್ ಮತ್ತೆ ಡೇಟ್ ಬ್ಲಾಂಕ್ ಇದೆ
ನಮ್ಮಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ ಅದು ನಿಮ್ಮ ಪ್ರಾಜ್ಞೆ ಸ್ನೇಹಿತರ ಮುತುವರ್ಜಿ ಆಗಿದ್ರೆ ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತದೆ ಕೋರ್ಟ್ ಏನ್ ಕೊಡ್ತಾರೆ ಅದ್ರ ಯಥಾವತ್ ನಕಲು ತಮಗೆ ಕೊಡ್ಬೇಕು ಕೋರ್ಟ್ ಅಲ್ಲೆಲ್ಲ ಫಿಲ್ ಮಾಡಿ ಕೊಟ್ಟು ನಿಮಗೆ ಫಿಲ್ ಮಾಡದೇ ಇದ್ದಾಗ ಕೊಟ್ರೆ ನಿಮ್ಗೆ ಅನನುಕೂಲ ಆಗುತ್ತೆ
regarding the appeal filed by me, my lord, that the dispute is the first is no DL, ME is not involved in the extent defense. And second is R2 is not the owner of the vehicle.
1 minute. Please share the details here.
Yes. Mathematical condition will be pending.
evidence, RW. Yes, please.
Appellant is aged about 47 years, occupation pump operator in Gram Panchayat, Mallur Gram Panchayat, and offending vehicle is a motorcycle. Period of treatment is 6 days. Nature of injuries, comprehensive fracture, verbal body, 30%, 30% permanent physical impairment in relation to spinal. And during the course of trial, 3 points they have raised at the insurance company, that the driver was not having a valid driving license, and the owner of the vehicle, R2 is not the owner of the vehicle. And for this exhibit P5, IMV report after the inspection, only after verification of the records, the IMV report was given to the R2, Abdul Qadir. He accepted, he admits the cross-examination also. And the notice, claim petition was also sent by the claimant to this Abdul Qadir only. He received it, he has not appeared. He was kept expected. But he has appeared as a defense witness, as a R1. Even though he was the respondent number 1, he has not appeared, but appeared as a defense witness. That during the course of defense witness, he has started a new story that the accident, the claimant fell down from a tree, and R2 insurance company, the suggestion given in the cross examination, that without giving the signal, hand signal, this accident was done. Even though they had disputed the accident ownership is also disputed. In the cross examination, they stated that the accident was happened by not giving the proper signal. But this R1 Abdul Qadir says that he fell down from the tree. But the order of the tribunal is very clear. At page number 15 of the 13, para number 11. The petitioner in support of his case has produced exhibit P1 FIR wherein 9/5/2015 the case was registered against the offending motorcycle. Exhibit P2 is the complaint. Exhibit P3 is the spot measure. Exhibit P4 is the sketch of the scene of occurrence, wherein we can see the accident took place towards the southern side of the road. Exhibit P5 is the motor vehicle report, wherein it is the opinion of the motor vehicle inspector that due to the human error, accident took place. Exhibit P6 is the wound certificate, wherein at the earliest point of time it is recorded that injuries are result of road traffic accident. The objection of the respondent, there is a delay of 3 days of delay in filing the FIR. For that, the explanation was given that the respondent has promised to settle the issue by paying some amount without approaching the tribunal. That was the explanation given for the delay in filing the FIR. Para 13 on careful perusal of the evidence PW1 as well as averments made in the complaint as per exhibit P2, it is specifically stated by the petition that the offending motorcycle assured to bear the medical expenses, but afterwards he did not come forward to pay the medical bills. As such, there is a delay of 3 days. This properly it was explained in filing the complaint. On perusal of the cross-examination directed by the PW1, no any suggestion by way of denial is put to the witness stating that there is no any assurance given by the offending motorcycle to bear the medical expenses. It was not denied. No doubt it is a contended by a second respondent that the offending vehicle bearing registration number KL Kerala registration 14J7580 is not involved in the accident, but during the course of cross-examination directed by the PW1, it is contended that the injured petitioner without giving any signal tried to take turn towards the right side, which resulted in the accident. Therefore, suggestion itself reveals that there was accident by the motorcycle of the offending vehicle. ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ ನಾವು ಓನರ್ ಅಲ್ಲಿ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿಲ್ಲ ಮರದಿಂದ ಬಿದ್ದದ್ದು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ ಸಿಗ್ನಲ್ ಕೊಡದೆ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅಬ್ಸರ್ವ್ ದಟ್ R1 ಇಲ್ಲಿ ನೋಟಿಸ್ ಕೊಟ್ಟರು ಕೋರ್ಟಿಗೆ ಅಪಿಯರ್ ಆಗ್ತಾ ಇಲ್ಲ. ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿಯವ್ರಿಗೂ ನೋಟಿಸ್ ಕೊಡ್ತಾರೆ ಓನರ್ಗೆ. He has not produced the document. ಯಾರು ಓನರ್ ಅಂತಿಕೊಂಡು. But he appeared before the court as a defense witness. ಇನ್ಸೂರೆನ್ಸ್ ನವರೇ ಪರವಾಗಿ ಬಂದು ಹೇಳ್ತಾರೆ R1 owner of the vehicle has been examined. R1 deposes strangely before the court, stating that he is not the owner of the insured vehicle. One of his relative friend has come from Kasaragod to attend the marriage function in a insured vehicle shelter, and it was parked by the side of the road. One person accidentally fell from the coconut tree, and false case has been registered against the insurance vehicle. ಕಥೆ ಹೇಳ್ತಾರೆ. As it could be seen that the petition notice was issued to the owner of the vehicle. In spite of it, the owner of the vehicle did not come forward and contest the case. For the first time before the tribunal, he is deposing that he is not the owner of the vehicle and the petitioner had fell from the coconut tree and sustained injury. But the IME report and medical report, they said it is a road accident. It is further relevant to observe that the second respondent has issued notice as per exhibit R3 to the owner of the vehicle to produce the documents. Respondent number 2, insurance company ಅವರು admit ಮಾಡ್ತಾರೆ notice issue ಮಾಡಿದ್ದೇವೆ exhibit 3 P3. In spite of issued the notice, owner did not come forward to produce the record. In exhibit P7, accident information report notice was issued to the owner Abdul Qadir. Respondent number 1, Abdul Qadir. Second respondent has not taken any steps to call for the RTO, concerned RTO to furnish the details of the ownership of the vehicle. If at all he is not the owner of the vehicle, the concerned RTO should have been examined, or the record should have been secured from the RTO concerned. No steps have been taken by the second respondent to get the information regarding the license of the offending motorcycle. Here, submission of the charge sheet regarding non-possessing of the driving license itself is not a ground to arrive at a conclusion that the offending motorcyclist had no driving license at the time of accident. Therefore, the negligence aspect apart from the face of the record, and as such, answer point number. regarding the medical treatment, my lord, RR number 16.
1 minute.
With your lordship's leave, my lord.
Only the notice.
With your lordship's leave, my lord.
Yes, please.
Lord, in the connected matter, my lord, where my friend appears in MFA 2588 of 2019, he was directed to serve a copy of his appeal memo by this court on 8/8/23. Copy is not served on him. Appeal memo copy.
Copy by RPD.
The Learned Counsel submits that by RPD has sent copies to you.
No, my lord, it has not come. I got the file, it did not come.
OC of the letter is as per the direction of the Honorable High Court of Karnataka interpretation number 22, dated 8/8, CH number 22. I am sending here with the copy of the appeal memorandum in the said MFA, which may kindly be acknowledged. RPD.
ಹೌದು, ನೀವು ಅದನ್ನ ಬರೆದು ಇಟ್ಕೊಂಡ್ರಿ, ಬರೆದು ಇಟ್ಕೊಂಡು ಟೈಪಿಸ್ಟಿಗೆ ಕೊಟ್ರಿ, ಟೈಪ್ ಮಾಡಿ ಅದನ್ನ ಅಪೀಲ್ ಮೆಮೊ ಕಾಪಿ ಮಾಡಿ ಕಳ್ಸಮ್ಮ ಅಂತ. ಅವ್ರು ಬಹುಶಃ ಟೈಪು ಮಾಡಿಲ್ಲ, ಕಳಿಸಿರ್ಲಿಕ್ಕೂ ಇಲ್ಲ.
ಇಲ್ಲ, ಕಳಿಸಿದೆ. Acknowledgement also, postal acknowledgement also it is there.
ಇಲ್ಲಿ ಅವ್ರಿಗೆ ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ, ಕಾಪಿ ಬಂದಿಲ್ಲ ಅಂತ ಅವರಿಗೆ. ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಇದೆ, ಅವ್ರ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ತೋರಿಸ್ತಿದ್ದಾರೆ, ಕವರಿಂಗ್ ಲೆಟರ್ ಜೊತೆ ಕಳಿಸಿದೆ, ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಇದೆ ಅಂತ.
ಅಲ್ಲ, who has signed, my lord? I don't know, because it's a residential.
ಅವ್ರ ಅಪೀಲಿನ ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಕಾಪಿ ನಿಮಗೆ ಅಲಾಂಗ್ ವಿತ್ ಕವರಿಂಗ್ ಲೆಟರ್, ರಿಜಿಸ್ಟರ್ ಪೋಸ್ಟ್ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಡ್ಯೂ ನಲ್ಲಿ ನಾನು ಅಲಾಂಗ್ ವಿತ್ ಕವರಿಂಗ್ ಲೆಟರ್ ಕಳಿಸಿದ್ದೇನೆ. ಆಫೀಸ್ ಕಾಪಿ ಆಫ್ ದಿ ಲೆಟರು ಇಲ್ಲಿದೆ ನೋಡಿ. ಪೋಸ್ಟಲ್ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ನನಗೆ ಬಂದಿದೆ, ಓ ಮಹೇಶ್ ಅವರೇ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತೇಳಿ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ ಅವರು. ಇನ್ನೊಂದು ಕಾಪಿ ನಿಮಗೆ ಕೊಡ್ಲಿಕ್ಕೆ ಹೇಳುವ. ಹಿ ಇಸ್ ರಿಕ್ವೆಸ್ಟಿಂಗ್ ಫಾರ್ ಒನ್ ಮೋರ್ ಕಾಪಿ. ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ.
And moreover, my lord, in my appeal, I have taken a ground that owner of the vehicle is not made a party. It is left to the choice of the, my lord, my learned friend. Because we have let in evidence, policy was also produced to show who was the owner. And RW1 was examined, and he said that he was not the owner.
Yes, Henry. Submission.
Sayavuddin was, my lord, is the owner as per the policy exhibit R2.
1 minute. Yes, please.
Insurance company, they have sent a notice that it has come in the evidence that they have sent a notice to the owner of the vehicle. Owner of the vehicle, thereafter, ಏನಾಯ್ತು ಅಂತ ತಗೊಂಡು ಅವರು ಹೇಳ್ತಾ ಇಲ್ಲ.
I think so, who is the owner, my lord? We have let in evidence that
the submission of the Learned Counsel for insurance companies that since you are for claimant, it is for the claimant to sue the insured, the owner of the vehicle, if he is insured with any insurance company. The burden is not upon the insurance company, that is the insurer, to bring to your notice as to who the owner is and what you have to do. His contention is that he has made some stranger as the owner of the party. That stranger is not at all the insured under us. Therefore, how can we indemnify the interest of a stranger?
Police have.
RW1 was examined. He has stated on oath that he was not the owner.
Owner of the vehicle after registration of the FIR. They have informed accordingly. This claimant has filed this appeal, and this fact is not denied by this Abdul Qadir. He says that I am the father ಮಾತ್ರ ಅಂತ ಹೇಳಿ ಯಾರ ಸ್ವೀಟ್ ತಗೊಂಡು ಹೇಳೋರು ಅಂತ ಹೇಳ್ತಾರೆ. ಯಾರ ಮೋಟರ್ ಸೈಕಲ್ ಅಲ್ಲಿ ಇಟ್ಟದನ್ನು ತಗೊಂಡು ಹೋಗಿದ್ದಾರೆ ಅಂತ.
Abdul Qadir has been examined as RW1. On oath, he says that you are not, he is not the owner. And policy produced
The
also.
contention of the claimant is that the father did not say appear and file his written statement. All of a sudden on fine day, strangely, he comes up in the witness box, appears in the witness box as your witness and says something, introducing a new story. That's what the argument of the learned counsel for the claimant.
Even policy is produced. The policy is also not in the name of Abdul Qadir, who has been shown as the owner. Owner, the Abdul Qadir examined as RW1. He states on oath, I am not the owner.
Indirectly, learned counsel for the insurance company is say cautioning you in a polite manner. Let's say you are facing a risk of not arraigning the true owner of the vehicle and the insured of the vehicle as a party. Therefore, can you think again before proceeding further? Is the caution
Just to avoid, my lord,
given by the learned counsel for the insurance company.
Send a copy of this appeal memo agreement.
ನೀವು ಬರ್ದೇ ಇದ್ರೆ ನಿಮ್ಗೆ ಕಾಪಿ ಕೊಡೋದು ಹೇಗೆ ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಅಪೀಲ್ ಅಂತಿದ್ದಾರೆ ಅವರು.
ಅಲ್ಲ, ಬೈ ರಿಜಿಸ್ಟರ್ ಪೋಸ್ಟ್ ಕಳಿಸ್ತಾರೆ ಎಲ್ಲರೂ.
ಕಳಿಸಿದ್ರೆ ನೀವು ನಿಮಗೆ ತಲುಪಿಲ್ಲ ಅಂತ ನೀವು ಹೇಳಿದ್ರಲ್ಲ.
ಅಲ್ಲ, ಇದು ಫೈಲ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಯಾಕೆಂದ್ರೆ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ದ ಸರ್ವಿಸ್ ಇಟ್ ಗೋಸ್ ಟು ದಿ ಕನ್ಸರ್ನ್ ಅಪೀಲ್ ಮೆಮೋ ಫೈಲ್. ಐ ಹ್ಯಾವ್ ನಾಟ್ ರಿಸೀವ್ಡ್ ದಿ ಅಪೀಲ್ ಮೆಮೋ ಬಿಕಾಸ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಅವೈಲಬಲ್ ಇನ್ ದಿ ಫೈಲ್.
ವಕೀಲ್ರಿ, ಈಗ ಅವ್ರು ಹೇಳೋದು ನಾನು ಆಲ್ರೆಡಿ ಒಮ್ಮೆ ಕಳಿಸಿದ್ದೇನೆ, ಅದರದ್ದು ಕವರಿಂಗ್ ಲೆಟರ್ ನಿಮ್ಮ ಎದುರು ತೋರಿಸ್ತಾ ಇದ್ದೇನೆ, ಪೋಸ್ಟಲ್ ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ನಿಮ್ಮ ಎದುರು ತೋರಿಸ್ತಾ ಇದ್ದೇನೆ. ಇನ್ನೊಮ್ಮೆ ನಾನು RPD ಅಲ್ಲಿ ಕಳಿಸಿದ್ರೆ ಅದು ಕೂಡ ಅವ್ರಿಗೆ ತಲುಪುತ್ತೆ ಅಂತ ಗ್ಯಾರಂಟಿ ಏನು? ಅವ್ರು ಇಲ್ಲೇ ಬಂದಿದ್ರೆ ನಾನು ಖುಷಿಯಿಂದ ಒಂದು ನಗು ಮುಖದಲ್ಲಿ ಕೊಟ್ಬಿಡ್ತಾ ಇದ್ದೆ ಅವರಿಗೆ ಕಾಪಿ ಅಂತಾರೆ.
RPD ಮೇಲೆ ಯಾರ ಸಿಗ್ನೇಚರ್ ಇದೆ ನೋಡ್ಬಿಡಿ ಸ್ವಾಮಿ. ಇಫ್ ಇಟ್ ಇಸ್ ಮೈ ಸಿಗ್ನೇಚರ್ ಐ ವಿಲ್ ಓನ್ ಇಟ್.
ಅವ್ರು ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹತ್ರ ಕಾಪಿ ಇಟ್ಟಿರ್ತಾರೆ, ನೀವು ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ನಾಳೆಯೋ ನಾಡಿದ್ದು.
ಅಲ್ಲ, ನಾನು ಕೋರ್ಟಿಗೆ ಬರ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದೇ ದಟ್ಸ್ ದ ಹೋಲ್ ಪ್ರಾಬ್ಲಮ್.
ನಿಮ್ಮ ಕ್ಲರ್ಕೋ, ಕಲೀಗೋ, ಫ್ರೆಂಡ್ಸೋ, ಗುಡ್ ಓಲ್ಡ್ ಫ್ರೆಂಡ್ಸ್.
ಯಾರು ಆಫ್ಟರ್ ಕೋವಿಡ್ ಐ ಆಮ್ ಅಲೋನ್. ದೇರ್ ನೋ ಒನ್ ಇಸ್ ವಿತ್ ಮೀ. ದಟ್ಸ್ ದ ಹೋಲ್ ಪ್ರಾಬ್ಲಮ್.
ಇನ್ನೊಮ್ಮೆ ಕಳಿಸ್ತೀರೇನ್ರಿ RPD ಯಲ್ಲಿ? ಕಳಿಸಿ, ಅವ್ರು ಸರಿಯಾದ ವಿಳಾಸ ಇದೆಯಲ್ಲ ವಕೀಲರದ್ದು ತಮ್ಮ ಹತ್ರ. ಆಮೇಲೆ ಮತ್ತೆ ಕಳಿಸಿ ಅದ್ರ ಮೇಲೆ ಇಲ್ಲ, ಈಗ ಅಡ್ರೆಸ್ ಚೇಂಜ್ ಆಗಿದೆ, ಡೋರ್ ನಂಬರ್ ಚೇಂಜ್ ಆಗಿದೆ ಅಂತಾನೆ ಹೇಳ್ಬಾರ್ದು. ನೀವು ಅವ್ರ ಜೊತೆ ಕನ್ಫರ್ಮ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಫೋನ್ ಮಾಡಿ ಅದ್ ಯಾವ ಅಡ್ರೆಸ್ ಹೇಳ್ತಾರೆ ಕಳಿಸಿ ಬಿಡಿ. ಇನ್ನೊಮ್ಮೆ
ವಕಾಲತ್ತಲ್ಲಿ ಹಾಕಿದ್ರೆ ಅಪೀಲ್ ಮೆಮೋ,
ವಕಾಲತ್ತಲ್ಲಿ ಹಾಕಿರೋ ಅಡ್ರೆಸ್ ಇದೆ ಅಂತೆ ನೋಡಿ.
ನನ್ನ ಅಪೀಲ್ ಮೆಮೋದಲ್ಲಿ ಇದೆ,
ಅವ್ರ ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಅಪೀಲ್ ನಲ್ಲೂ ಇದೆ ನೋಡಿ. ಅದೇ ನೋಡಿ ಹಾಕಿ ಬಿಡಿ. ಈಗ ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡ್ಬೋದೇನ್ರಿ ಅವ್ರ ಅಪೀಲ್ ನಲ್ಲಿ ವಕೀಲ್ರೆ?
ಅದು ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ರೆ ನಾನು, ಯಾಕೆಂದ್ರೆ ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡಬಹುದು, ಡಿಲೇಯಿಂಗ್ ದಿ ಇಂಟ್ರೆಸ್ಟ್, ಬಟ್ ಮೈ ಓನ್ಲಿ ದಿಸ್ ಥಿಂಗ್ ಟುಮಾರೋ ಆಫ್ಟರ್ ಹಿಯರಿಂಗ್ ದೆನ್ ಅಗೇನ್ he should not take time to make the insurer the party. ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಮುಂಚೆನೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅವರಿಗೆ, ಓನರ್ is not made a party. That is my main ground. Claim petition is not maintainable because
ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಅಪೀಲ್ ನಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 6 ನಲ್ಲಿ ಪೇಜಿನ ಬಾಟಮ್ ನಲ್ಲಿ ಕ್ಯಾಪಿಟಲ್ ಲೆಟರ್ಸ್ ನಲ್ಲಿ 3 ಸಾಲು ದೊಡ್ಡದಾಗಿ ಬರೆದಿದ್ದೀನಿ ನಾನು. ಅನ್ಲೆಸ್ ದಿ ಓನರ್ ಹೂ ಇಸ್ ದಿ ಇನ್ಶೂರ್ಡ್ is not sued by the claimant, the indemnifier, the insurer cannot be held liable ಅಂತ. ತಾವು ಅದನ್ನು ಗಮನಿಸಿರ್ಲಿಕ್ಕಿಲ್ಲ. ನೀವು ಗಮನಿಸಿದ್ರೆ ಬಹುಶಃ IAGI ಅದೆಲ್ಲದನ್ನು ಮರೆತು ನೀವು ಬೇರೆದೇ ಏನೋ ಒಂದು ಲಿಬರ್ಟಿ ಕೇಳ್ತಿದ್ರಿ ಕೋರ್ಟ್ ಇಂದ ಅಂತ ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ. ಅದ್ರೊಳಗೆ ಕಾಪಿ ಕಳಿಸಿ ಬಿಡಿ ಅವರಿಗೆ. ಯಾವ್ದು learned counsel from both sides appear at the request of the learned counsel for the respondent in MFA 2588/2019. The learned counsel for the appellant in this said matter undertakes to furnish him a copy of memorandum of appeal along with copy of IA 1/19, the registered post acknowledgement due, days time as period is granted to file objections if any to IA 1/19 in the said appeal. List the matter immediately after 10 days. ಇವತ್ತು ಕಳಿಸಿ ಅವರಿಗೆ ಅದು ಹೋಗಿ ಬಂದ್ಬಿಡ್ಲಿ ಅವರು.
Bill number 54, Manjula and Tejasvi. Swami Shiva Prakash, bench for R124, R5 and 6, sir.
Next.
Challenging the non-consideration of constitutional aspect for the tribunal.
Entry model ಪ್ರಕಾರ award amount deposit ಮಾಡಿದ್ದೀರಾ?
We
Deposit.
have deposited 50.
Respondent ವಕೀಲರು ಕೂರಿಸ್ರಿ ಇನ್ನೊಮ್ಮೆ R124.
Swami Shiva Prakash, correspondent 1 to 4, respondent 5 and 6, third.
We have deposited 6,87,850, 50% of the award amount, inclusive of interest.
You are challenging liability or quantum?
Quantum of compensation and also non-consideration of conflict and negligence aspect penalty. The case of death, your lordship.
Let the other side come.
Yes.
Learned counsel for the appellant physically present, learned counsel for the respondent neither present physically nor through video conference. This the matter in the next week.
Bill number 56, Ganesh R, HS Lingaraj.
The Compensation Act. Enhancement of the award.
Next week. Let the other side be present next week. Yes, please.
It is something 2009. Minimum wages ಪ್ರಕಾರ 4,000 ತಗೊಂಡಿದ್ದಾರೆ. I have less merits in the case. I requested the other side to refer the matter to ಅದಾಲತ್ನಲ್ಲಿ workman compensation ಆಗಿರುತ್ತೆ. ನಾವು ಡೌನ್ ಸಂಬಂಧ ಕೊಡಕ್ಕೆ ಬರಲ್ಲ. Has to be decided by the court. As per the norms ಎಲ್ಲ ಸರಿ ಇದೆ.
ಅಲ್ಲಿ ನೀವು ಏನ್ ಕೇಳ್ತಿದ್ದೀರೋ ಅದನ್ನ ಇಲ್ಲಿಯೇ ಇಬ್ರು ಹೇಳಿದ್ರೆ we can record it and pass a judicial order.
I appear for the second respondent. Even he is not working.
ಎದುರುಗಡೆ ವಕೀಲರು ಮೂಡ್ ಯಾವಾಗ ಚೆನ್ನಾಗಿರ್ತದೆ ನೋಡಿ ಜೊತೆ ಫ್ರೆಂಡ್ಲಿ ಆಗಿ ಮಾತಾಡಿ ಒಂದು ಬಿಸಿ ಕಾಫಿ ಕುಡಿಸಿ ಹೋಗ್ತಾರೆ ಸೆಟಲ್ಮೆಂಟ್ ಗೆ ಅಲ್ವೇನ್ರಿ ಹ್ಞೂ ಅಂತಿದ್ದಾರೆ ನೋಡಿ ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್
ಇದರಲ್ಲಿ MBC ಕೇಸಲ್ಲಿ he is not working most income ತಗೊಂಡು ಅವರಿಗೆ ಕೊಡ್ತಾರೆ. ಇದರಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ರು ಅಲ್ಲಿ 4,000
ಈಗ ಅವ್ರು ಬಂದ್ರು ಏನ್ರಿ ಏನಾದ್ರಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಆಗ್ತದ? ಅವರೇನೊಮ್ಮೆ ಲೋಕ ಅದಾಲತ್ ಕೇಳಿದ್ವಿ ಅವರು EC ಆಗಿರೋದ್ರಿಂದ ಲೋಕ ಅದಾಲತ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಅಂದ್ರು. ಹಾಗಾಗಿ ಲಿಂಗರಾಜ್ ಅವರು ಯಾವ್ದಾದ್ರು ಒಂದು ಅಮೌಂಟ್ ಗೆ ಒಪ್ಪಿದ್ರೆ ನಾವು ಇಲ್ಲೇ ಕೋರ್ಟಿನಲ್ಲಿ ಅದನ್ನ ರಿಪೋರ್ಟ್ ಮಾಡಬಹುದು ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ ಅವರು.
Unfortunately, in this case, I am unable to accede to the request because it's a case under Compensation Act and interest, as per the law laid down, the insurer is not liable. My London fund is asking for interest. Interest owner ಮೇಲೆ ಹಾಕ್ತಾರೆ
ಅಂತ ಕೇಳ್ತಿದ್ದಾರೆ ಅವರು. ನೀವು ದುಡ್ಡು ಜಾಸ್ತಿ ಮಾಡಿದಾರೆ ಇಂಟ್ರೆಸ್ಟ್ ಬೇಕಾದ್ರೆ ಬಿಡ್ತಾರೆ ಅಂತ ನೋಡಿ.
ಅದು ಆಯ್ತು, ಅದು ವೆರಿ ಅದಾಲತ್ಗೆ ಹೋಗ್ಲಿ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ನೋಡೋಣ ಬೇಕಿದೆ ಅವ್ರ ಹತ್ರ ಕೂತ್ಕೊಂಡು.
ಅದಾಲತ್ತಲ್ಲಿ ಆಗಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಂತೆ.
ನನ್ನ ಪ್ರಕಾರ
ಆಗಿರೋದ್ರಿಂದ ಜುಡಿಷಿಯಲ್ ಆರ್ಡರ್ ಬೇಕು ಅಂತ.
I felt that would be more appropriate. Your lordship may extend time by 2 weeks. I will sit along with my learned friend. What best we can do, we'll do.
Good. Learned counsel from both sides present and submit that since it's a matter under Workmen's Compensation Act bracket, Employees Compensation Act at present. We are trying to find out the possibility of settlement between them so that they can report the same in the court. With this, they pray for 2 weeks accommodation. The time as paid is granted. But ಹೆಚ್ಚು ಸಮಯ ತಗೊಳ್ಬೇಡಿ 2019 matter 2 weeks.
Much obliged.
57, Jagadish HT. So 57.
But as well,
Bajaj Alliance Generations Company Limited. Response number 2, Bajaj Alliance Generations Company Limited.
whereas the memorandum of appeal into judgment heard the submission. Issue note, emergent notice to the issue notice to the respondent. Learned counsel Sri Pradeep so and so, who is physically present. Accept notice for respondent number 2, the learned counsel for the appellant to furnish with the law copy given within 3 days to the learned counsel. Appellant to pay the necessary process furnished copies in the registry is not already done within a week from today. Yes, call for inside is not already called.
Number 58, Ravi Shankar Shastri.
Appellant.
Respondent number 2, Royal Center Insurance Company Limited.
Ravi Sundram Mary Ilventry.
Ravi S. Samprat. Yes, Ravi S. Samprat.
HS Lingaraju.
ಇದ್ದಾರಾ ನೀವು ಕೂಗ್ಸೋರು ಇಷ್ಟೊತ್ತಿದ್ರಲ್ಲ
HS Lingaraju.
ಕೇಸ್ ಮುಗಿಸ್ಕೊಂಡು ಸ್ವಿಚ್ ಆಫ್ ಮಾಡ್ಕೊಂಡು ಹೋಗುತ್ತೆ ಇದ್ದಾರೆ
O Mahesh.
ರಾಯಲ್ ಸುಂದರಂ ಇದ್ದೀರೇನ್ರಿ ನೀವು?
Me, my lord.
ರಾಯಲ್ ಸುಂದರಂ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಲಿಮಿಟೆಡ್.
I am there, my lord. I am there.
ಇದ್ದೀರಾ? ತಗೊಳ್ತೀರಾ ನೋಟಿಸು?
ಯಾವ್ದ್ರಲ್ಲಿ ಸರ್?
ಇನ್ಯಾರಲ್ಲಿ ನೋಟಿಸ್ ಕೊಡ್ತೀವ್ರಿ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿಯವರಿಗೆ ನಾವು MFA ನಲ್ಲಿ
Number 58.
ಸೀರಿಯಲ್ 58 ಇರಲ್ಲ ಅವರು
ಅಲ್ಲ ಕಾಪಿ ಮೇ two sets of
ಮ್ಯಾಟರ್
ಅಲ್ಲ two sets of copy may be sent to me, my lord, because one set I have to send it to the company to obtain the necessary power and documents.
ನಮಗೆ ಸಂಪ್ರತಿ ಅವರೇ ಬೆಟರ್ ಅನ್ಸುತ್ತೆ.
Ravi Samprati would be better, my lord.
ಯಾಕಂದ್ರೆ ಅವ್ರಿಬ್ರು ಒಟ್ಟಿಗೆ ಕಾಫಿ ಕುಡಿತಾರಂತೆ.
ಅದು ಒಳ್ಳೇದು ಬೆಟರ್.
ಸರಿ ಅರ್ಧ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಪ್ರೀವಿಯಸ್ ಆರ್ಡರ್ನೇ ಹಾಕಿ R2 ಲರ್ನ್ ಕೌನ್ಸಿಲ್ ರವಿ ಸಂಪ್ರತಿ ಮಾಡಿ ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡಿ. ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಉಳಿದವ್ರಿಗೆ ಪ್ರೋಸೆಸ್ ಕಟ್ಟಿ ಬಿಡಿ R1 ಅಥವಾ ಅವ್ರದ್ದೇನ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಕೇಳ್ತೀರಾ? ಲೈಬಿಲಿಟಿ ಯಾರ ಮೇಲೆ ಇದೆ ಈಗ?
ಇಲ್ಲ ಸರ್, ಕ್ಲೈಮ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. So I will take out. Claim was dismissed, my lord.
ಹಾಗಾದ್ರೆ ನೀವು ಅವ್ರ ಮೇಲೆ ತಗೊಳ್ಬೇಕು.
I will take.
ತಗೊಳ್ಳಿ LCR.
Number 59, Ravi Shankar Shastri. Respondent number 2, New India Insurance Company Limited.
Well, my lord, I will see.
ನ್ಯೂ ಇಂಡಿಯಾ ಇದ್ದೀರೇನ್ರಿ ನೀವು? ನೀವಿಲ್ಲ. ಯಾರಿದ್ದಾರೆ ನ್ಯೂ ಇಂಡಿಯಾ? ರವಿ ಸಂಪ್ರತಿ ಇದ್ದಾರಾ?
ಒಕ್ಕಲಕ್ಕೆ ಚೆಕ್ ಕೊಡ್ತಾ ಇಲ್ಲ.
ಯಾಕ್ರಿ ಯಾವ ಪಟ್ಟು ಗುದ್ದಾಡಿದ್ರ? ಬಿಲ್ ಸೆಟಲ್ ಮಾಡ್ತಿಲ್ಲ ಅಥವಾ ಬೇರೆದೇನೋ ಫೇವರ್ ಕೇಳಿದ್ರಿ? ಇದು ನಮ್ ಫ್ರೆಂಡ್ ಇಂದ ಗಾಡಿ ನೀವು ಹೂ ಅಂತ ಹೇಳಿ ಪಾಲಿಸಿ ಇಶ್ಯೂ ಮಾಡಿ ಅಂದ್ರೆ ಇಲ್ಲದೆ ಇರೋ ಗಾಡಿಗೆ ಅದು ಪ್ರಾಬ್ಲಮ್ ಇರ್ತದೆ ಅವರದು.
ನಾವು 10 ದಿನ ಅಂತ ಆರ್ಡರ್ ಮಾಡ್ತೀರಾ, ನಾವು ಕಳ್ಸಿದ್ರೆ 2 ಸೆಟ್ ಕೊಟ್ಟು ಕಳ್ಸ್ತೀವಿ ಅಂತಾರೆ, ಇಮಿಡಿಯೇಟ್ ಫಾಲೋ ಅಪ್ ಮಾಡ್ತೀವಿ.
ದೊಡ್ಡ ಪ್ರಾಬ್ಲಮ್ ಅದೇ. ಕೆಲವು ಬ್ಯಾಂಕ್ ಅವ್ರದ್ದು, ಕೆಲವು ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪ್ನಿ ಅವ್ರದ್ದು ಅವರು ಹೊಟ್ಟೆ ತುಂಬಿದಾಗೆ ಆಡ್ತಾರೆ ಹೊರತು ಕೌನ್ಸಿಲ್ ಹೇಗೆ ಅಸಿಸ್ಟ್ ಮಾಡಬೇಕು ಟೈಮ್ಲಿ ಅನ್ನೋದನ್ನ ಮಾಡಲ್ಲ. ಅದು ಅನಾನುಕೂಲ ಆಗುತ್ತೆ. ಮುಗಿಸ್ಕೊಡಿ. ಮಹೇಶ್ ಇದ್ದೀರೇನ್ರಿ? ನ್ಯೂ ಇಂಡಿಯಾ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ. ಇದ್ದೀರಾ? 2 ಕಾಪಿ ಕಳಿಸಿ ಅವ್ರಿಗೆ. ನಿಮ್ಮ ಅಡ್ರೆಸ್ ಗೊತ್ತಂತೆ, ಬರ್ತಾರಂತೆ.
ಆಯ್ತಾಯ್ತು.
ರವಿಶಂಕರ ಶಾಸ್ತ್ರಿ ಅವರು.
ಅದೇ ನಮ್ಮನೆ ಹತ್ರನೇ ಇದ್ದಾರೆ.
ನೋಡಿ, ಇಬ್ರು ಪರಸ್ಪರ ಪರಿಚಯ. ಒಟ್ಟಿಗೆ ಬೈಟು ಕಾಫಿ ಕುಡಿಗೆ ಆಗ್ತದೆ. ನೋಟಿಸ್ ಮಾಡಿ. R1 ಡಿಸ್ಪೆನ್ಸ್. R2 learned counsel Sri O Mahesh. Learned counsel for the appellant to furnish copy of memorandum of appeal along with annexures if any to the study learned counsel for R2 within a week from today and file a complaints memo. List the matter after 10 days. Yes.
Bill number 60, Ravishankar Shastri. Respondent number 2, Yetko Tokyo Generation Company Limited.
ಅಲ್ಲೇ ಇದ್ದಾರೆ, ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ. ನೋಟಿಸು R1 ಡಿಸ್ಪೆನ್ಸ್. R2 learned counsel Sri Vijay Kumar. Copy bantala acknowledges the receipt of the copy of the memorandum of appeal with annexures. 2 weeks time is granted to file wakalat by R2 LCR. Yes.
Bill number 61, Mamta DN. Bill number 61, Mamata DN. Respondent number 2, National Insurance Company Limited.
None appear in this matter. List the matter on. Ten. Yes.
Serial number 63, you got to entry mark.
Blood serial number 62. Interim order may kindly be extended.
ಬೆಳಗ್ಗೆ ನೀವು ಸಬ್ಮಿಟ್ ಮಾಡ್ಲಿಲ್ವಲ್ರಿ?
ಹೌದು ಹೌದು ಮಾಡಿದೆ. ಅದು ರೀಚ್ ಆದಾಗ ಹೇಳಬೇಕು ಅಂತ ಹೇಳಿದ್ರಿ ತಾವು.
Yes, Mr. Mahesh. 62, Manoj.
62.
63. 62 ನಲ್ಲಿ the council has not served a copy of appeal memo in 1485 of 2017.
62 is adjourned.
Appeal. 63.
62.
Yes.
Number 62, sir.
We are in serial number 62, please. 62.
My appeal, my lord, is on question of, my lord, the negligence and quantum.
ಅವರು ಮಹೇಶ್ ಅವರು ಬೇರೆ
Probably is confusing.
no, he is arguing in some.
The date of accident, my lord, is
ನೀವು ಇದ್ದೀರಿ ಇದರಲ್ಲಿ serial number
21/5/2020
62. Read petition 70 of
ಹೌದು, ಹೌದು.
2019.
8 PM.
ಅದು ನಮ್ದು ಅವ್ರು ಬೇರೆ ಡಿವೈಸ್ ಅಲ್ಲಿ ಬೇರೆ ಕೋರ್ಟ್ ನಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ರೆ ಇದನ್ನ ಮರ್ತ್ಬಿಟ್ಟಿದ್ದಾರೆ.
This is, my lord, one
ಮಾಡಿಲ್ಲ ಅವರು.
petition of aged about
ಕೇಳುವ,
28
ನಿಮ್ಮ
years. Said to be a building contractor earning rupees 59,000 per.
Entry modern the continuous extend ಆಗ್ಲಿಲ್ವಲ್ರಿ? ಮಧ್ಯ ಬ್ರೇಕ್ ಇದೆ ಅಲ್ವೇ? ಹೋಸರ್ತಿ ಸಾಹೇಬ್ರೆದ್ರು ಒಂದು ಸ್ಮೈಲ್ ಕೊಟ್ಬಿಟ್ರಿ, ಪ್ರೇ ಫಾರ್ ಟೈಮ್ ಇಂಟ್ರಿಮ್ ಸ್ಟೇ ಅಂತ. ಎಸ್ ಅಂದ್ರು.
ಇಲ್ಲ ಒಂದ್ಸರಿ ಏನ
ಅದೇ ನೋಡಿದ್ರೆ ಎಲ್ಲದೂ ಗೊತ್ತಾಗ್ತದೆ. Entry model is granted, is extended 2 weeks. Yes.
Oh, please.
Serial number 63.
The interim order is extended by 2 weeks from today.
Serial number continuation. Serial number 64. Vigneshwara U. SK Acharya for respondents.
My lord, in this matter, I am appearing for the respondent, my lord. Short accommodation till Tuesday, my lord. I am ready in the matter.
ನೀವು ವಕಾಲತೆ ಹಾಕಲಿಲ್ಲ ಇನ್ನು?
Well, I will look into the matter. You lost my height. I will look into this matter. You lost my height on Tuesday, my lord.
4 ವರ್ಷ ಆಯ್ತು, ಇನ್ನೇ ಹೋಗಿ ಲುಕ್ ಮಾಡ್ತೀರಿ?
ಇಲ್ಲ ನಾನು ವ್ಯವಸ್ಥೆ ಮಾಡ್ತೇನೆ.
Learned counsel for the petitioner is neither present physically nor through video conference. Learned counsel for the respondent alone is appearing through video conference, hence the matter could not be proceeded today. List the matter in the week after next. In the meantime, the learned counsel for the respondent to file his wakala without.
Please, my lord, grateful.
Finally,
65.
primary. 65, 60.
Serial number 65 ಏನಾಗಿದೆ? ಇಲ್ಲ ಅನ್ಸುತ್ತೆ. ಆಗಿದೆ. ನನ್ನ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ. ನಿಮ್ದು ಎಷ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್? 60 ನೋಡಿ. ಇವ್ರು ಯಾರಿಗೂ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅಡ್ಜರ್ನ್ ಅಂತಿದ್ದಾರೆ. ನೀವು ಕೂತಿದ್ದು ನೋಡ್ಲಿಲ್ಲ ಅವರು.
At the request of junior counsel for the petitioner who submits that her senior is not well, as a final last opportunity, it's time as bread is granted.
1 week ಅಡ್ಜರ್ನ್ ಆಗಿದೆ ಅಂತ ನೋಡಿ, ಬೆಳಗ್ಗೆ ಮೆನ್ಷನ್ ಕಾದ್ರು ಸುಮ್ಮನೆ. ಎಸ್.
Serial number 67. Final matter. P. Suresh. Hole Basappa C. Bastur for respondent 1. R. Hemraj for respondent number 2.
67 ಆಗಿದೆ. ಜೂನಿಯರ್ ಸೆವೆನ್.
I appear for respondent number 1. 67.
Learned counsel for the appellant neither present physically nor through video conference. Learned counsel for respondent number 1. One alone is physically present. ಈಗ ವಕೀಲರು ಇಲ್ಲ, ಜಾಸ್ತಿ ಟೈಮ್ ಕೊಟ್ಟರು ಇಲ್ಲ. ನಾನು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದೆ ಅಂದ್ರೆ ಅವ್ರು ಆಮೇಲೆ ಬಂದು ನಾನು ಬೆಳಗಿನ ಮೂವ್ ಮಾಡಿದ್ದೆ ಅಡ್ಜರ್ನ್ ಆಗಿತ್ತು ಅಂದ್ರೆ ಏನ್ ಮಾಡೋದು? ಇಲ್ಲಿ ಕಂಟಿನ್ಯೂಸ್ ನನ್ನ ಪೇರ್ ಅಂತಿದೆ ಓಲ್ಡ್ ಮ್ಯಾನ್. No liability is fixed upon you.
Lord, I make one submission.
Yes.
Lord, what has happened before the tribunal, the MEC, the council appearing for the insurance company filed an application seeking direction from the court to the owner was appearing. Owner to furnish the policy copy and DL copy. Even in spite of sufficient opportunity given by the tribunal, the owner failed to provide the policy copy and DL copy. On that basis, my lord, the tribunal fixed the liability against the owner. Now, today morning, my apparent counsel furnished me the copy of the policy, saying that sir, policy ittu avuttu anta heli. Avaga ನಾನು ಕೇಳಿದೆ, sir, your owner was appearing before the tribunal. Even in spite of direction by the court, he failed to produce. Because of that, the tribunal passed the liability against the owner. ಅದಕ್ಕೆ ನಾನು ತಮ್ಮ ಮುಂದೆ ಇದನ್ನ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಸರ್. ಅವಾಗ ಅದರಲ್ಲಿ ಓನರ್ ಅಪಿಯರ್ ಆಗಿದ್ರು, WS ಫೈಲ್ ಮಾಡಲಿಲ್ಲ. ನಾವು ಕಾಪಿ ಕೇಳಿದ್ವಿ, ಕಾಪಿನೂ ಕೊಡ್ಲಿಲ್ಲ ಇನ್ಶೂರೆನ್ಸ್ ಕೋರ್ಟ್ಗೆ. ಸೊ ದಿ ಟ್ರೈಬ್ಯುನಲ್ ಫಿಕ್ಸ್ಡ್ ದಿ ಲಯಬಿಲಿಟಿ ಅಗೇನ್ಸ್ಟ್.
ನೀವು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ನೀವು ಹಾಕಿದ್ದೀರಿ.
I denied the
ಲಯಬಿಲಿಟಿ.
liability.
ಈಗ ನಿಮಗೆ ಪಾಲಿಸಿ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದ್ದಾರೆ, ಈಗ ಕೊಟ್ಟರು ಸರ್, ಬೆಳಿಗ್ಗೆ ಇಸ್ಕೊಂಡೆ ನಾನು.
ಆಗ ನಿಮ್ಮ ಮುಂದಿನ ನಡೆ ಯಾವ ರೀತಿ ಇರುತ್ತದೆ?
According to this copy, policy was post. The policy was just now, morning I saw this. Even I spoken to the insurance company officials also. Sir, policy copy DL ಎಲ್ಲ ಕೇಳಿದ್ರು, ಅದ್ರಲ್ಲಿ ಯಾವ್ದು ಕೊಡ್ಲಿಲ್ಲ, ಅದಕ್ಕೆ ಕೋರ್ಟಲ್ಲಿ ಮಾಡಿದ್ರು ಅದನ್ನ. ಸರ್, ಈಗ ಪಾಲಿಸಿ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದನ್ನ ಹೇಳಿದ್ದೀನಿ.
ನನಗೆ ಅಪೀಲ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ಗೆ ಡಿಸ್ಮಿಸ್ ಮಾಡುವ ಅಂತಿದ್ದೆ ಇಲ್ಲಿ. ಬೇಡ
ಅಲ್ಲ,
ಸುರೇಶ್ ಅವರು
submission I made to the court. This is ಬೇಕಾದ್ರೆ ಎರಡು ವಾರ ಕಾಲಾವಕಾಶ ಕೊಡಿ.
For the appellant not present, counsel for respondent number 1 alone is physically present. Hence the matter could not be proceeded today. List this matter on 31/10. ಬರ್ಲಿ, ಮುಂದಿನ ವಾರ ಬರ್ತದೆ 31/10.
ಆದ್ರೆ ಔಟ್ಸೈಡ್ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ಪ್ರಯತ್ನ ಮಾಡ್ತೀನಿ. ರಿಯಲ್ ಕಾಪಿ ಕೊಟ್ರೆ ನಾವೇ
ನೀವು ಸ್ವಲ್ಪ ಬೆಟರ್ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇದ್ದೀರಿ, ಸ್ಟ್ರಾಂಗ್ ಹೋಲ್ಡ್ ಅಲ್ಲಿ ಇದ್ದೀರಿ. ಅವ್ರು ನಿಮ್ಮ ಹತ್ರ ಚೂರು ಓಡ್ಕೊಂಡು ಬರ್ಲಿ. ಈಗ ನಾನೇನು ಆರ್ಡರ್ ಮಾಡ್ತಿಲ್ಲ, ಬರೀ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಅಷ್ಟೇ. ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳೋದು ಬೇಡ ಅನ್ನಲ್ಲ.
10 days time.
10 days ಟೈಮ್ ಕೊಡೋಣ ಅಂತ, ನೋ ಪ್ರಾಬ್ಲಮ್. ಹಾಕೊಳ್ರಿ 6/11 6/11 more than 2 weeks ಆಯ್ತು ಮಾಡಿ.
Bill number 68, O Mahesh, Shikumar MB, passport 1 to 3, connected matter. Bill number 68, O Mahesh.
ಶಿವಕುಮಾರ್ ಇಲ್ಲ ಅಲ್ವಾ? None appear in this matter. I will display video conference since the matter could not be proceeded today.
Bill number 69, Suresh M. Rathur.
Has been directed to file Makala. After has not yet received my just 2 weeks time.
Remove the citation in the ಅವ್ರವ್ರದ್ದೇ ಸಿಮಿಲರ್ ಕೇಸಲ್ಲಿ ಬಂದಿರೋದೆಲ್ಲ ಹಾಕಿದ್ದಾರ್ರಿ ಸೈಟೇಷನ್. Learned counsel for the appellant neither present physically nor through video conference. Learned counsel for respondent number 2 alone is present and placed for a short accommodation. List the matter the week of the next as well. Yes.
70. D. Vijay Kumar.
Released by the case of the challenging liability negligence and matter of company. Need between two vehicles.
Car dashing a parked lorry.
Parked bus.
Parked bus.
Which was parked on the extreme left side of the road.
You prefer addressing argument right now or when the other side counsel comes?
It's fair on my part to release brother.
Let him come.
When I'm seeing exoneration, it is better to.
Learned counsel for the appellant alone is present. Learned counsel for the respondent neither present physically nor through video conference. Hence the matter should not be proceeded today. You have any preferential date?
Give it to them. Any
List the matter in the next week.
Serial number 71, Suresh M. Latur. Government advocate for all 102.
None appear in the matter. I will physically have video conference since the matter could not be proceeded.
72. Serial number 72, Chandrasekhar R.
Same out.
Serial number 7. Serial number 74, O Mahesh.
Learned counsel for respondent number 1 and 2 alone is physically present. Learned counsel for the appellant not present. Any preferred date for you? Hence the matter could not be proceeded today. List the matter the week after next.
Serial number 75, Prasanna Kumar CS, Chandrakant Patil for respondent.
None appearance the matter could not be proceeded today.
Serial number 76, Revana Bellari, T. Somsekhar for respondent 1 and 8.
Correspondence matter.
Learned counsel for the petitioner neither present physically nor through video conference. Learned counsel for respondents alone present. Hence the matter could not be proceeded to. I can give you date of your choice. Even tomorrow also no problem. Day after no problem. Monday no problem. List the matter on 3, 11. Friday ಆಗ್ತದೆ ತೊಂದರೆ ಇಲ್ವೇ?
My lords. So he has to come from down here. Junior is almost seeking dates, date of hearing.
Date ಕೊಟ್ಟಿದ್ದೇವೆ so that he can come. No problem. ಯಾರಾದ್ರೂ ವಕೀಲರು ಡೇಟ್ ಕೇಳಿ ನಾವು ಮಾಡ್ತೀವಿ ಸ್ವಾಮಿ ಡೇಟ್ಗೆ ಅಂದ್ರೆ ಅದಷ್ಟು ಖುಷಿ ಏನಿದೆ ರೀ ಆಯ್ತ್ರಿ.